You will have it today or by Monday you will get it. Mr. Bora, sorry, we have to go against you, but we have provided for a liberty because we have not examined the minutes of the meeting of the district scrutiny committee in terms of the orders, because that was not under challenge. We have upheld, we have directed for his provincialization. That order passed by the director, we have interfered. We have directed that he would be entitled to the benefits from the date of his original provincialization. But we have given you a liberty to approach the jurisdictional tribunal for, if you have any right, you can establish this there. This will be subject to that. Disposed of. Mr. Khan, we have, for the time being, upheld your provincialization. It's not yours, actually, it's Mr. Padgiri's. Mr. Bodhagur, we have interfered with the selection. We have asked for a review selection. And we have held that the ACR that you have, the initial one at Annexure 6, that would be considered. They will consider your national award. If they give you a mark, give it. And we have also held that he would not be entitled to any mark for the experience component. But we have confined the selection to the persons who were there in the original. This is the best I could do. Disposal. We have interfered with the order of termination. The period of leave prior to termination, we have said that you will not be entitled to any salaries, but the period would be notionally calculated. And the period after termination, till your superannuation, you will be deemed to be in service with all full back wages. Okay? You don't seem to be very happy.
No. Good or bad?
Good or bad, that will be time will say. We have held that the proviso clause B2 proviso, second proviso to 311, they said they have invoked. We have said there is no material. Mr. Khan, I'm sorry. We have rejected your petition, holding by following the decision of the Supreme Court, latest decision in Rajkumar. On the day of consideration, the rule that holds the field will be there. And we have also interfered with the order, speaking order passed by the director, saying that that is not supplementing, supplanting the rules. Test it. Let's see what happens. Dismissed.
Yes.
The petition is held to be devoid of any merit, and accordingly the same stands dismissed. Writ petition 1792/2023 stands allowed, and the writ petition 3368/2023 stands dismissed. So you can smile for the time being. We have directed that the order which was passed by the jurisdictional DU allowing you to hold the charge will continue to exist till a regular selection is made.
7.
Mr. Soma, Mr. Bhardwaj, we have upheld your provincialization. We have asked them to take the matter to its logical conclusion and pass appropriate orders. However, because we have not examined the minutes of the district scrutiny committee here because there was no challenge to that. So we have that appeal that he has filed, we have asked them to take it to its logical conclusion. But your order is to be passed within 3 months, and for the appeal we have given 3 months, 2 months, and appeal we have given 3 months.
Right.
Writ petition
I'll
disposed of. Sorry, we couldn't come in your favor. We have held that we have quoted 2 Supreme Court judgments and drawn a conclusion that your period having come to an end, this court is not empowered to put you back. Accordingly, we have said that you have a way out if you want before the civil court. And the decision that you relied upon, Mr. Saidur Rahman case, we have said that the distinguishing factor is in that case, it was between the currency period that the petitioner had come up. So in that view of the matter, we have not, we have to bullish, but you have said that you have not received your salaries from April 2023.
Paid. Everything has been
Everything has been paid. Dismissed. That all of them. You will have it today or by Monday you will have it.
Yeah, please, Your Lord.
Hmm.
Lordship, I would like to mention one IA for listing. Did they?
Last of us will change.
Yeah, please, Your Lordship, I'd like to mention for listing to IA, my lord.
All listing matters, give him, he will give the dates.
May I please, Your Lord? So I'd like to mention item number 17, 17.
17.
17. Motion.
Going?
So I have been instructed to withdraw this petition. Okay.
On the prayer of Mr.
T. Sutia, Lord.
T. Sutia, learned counsel for the petitioner. Mr. T. Sutia, learned counsel for the petitioner submits on instructions that he may be permitted to withdraw the present bail applications. Also, prayer is not objected to by Mr. B. Sharma, learned petitioner PP. Accordingly, the bail application stands dismissed on withdrawal. I was about to give you bill today.
I'm obliged.
PMGY scheme. He is a counselor. What role will they have? 5,000 rupees. Documentary evidence.
Oh, yes.
Right? 5,000 rupees. Anyway, try. Yes.
So yesterday, your lordship allowed my prayer to list a bail application today, but somehow due to long queue,
Monday.
or can it be taken at 2 o'clock? But
Today would be difficult because
on the same
very big. Whatever, same issue.
small matters, same issue, my lord.
Which one?
Once I had been, my lord, this FIR, my lord. Second time FIR is lost, my lord, when he went to give his record his statement under 161 before the police. So he was arrested in the police station itself, my lord. FIR is lost by the same informant in which, my lord, we have obtained bail.
I can only
Same
issue
cause of
a,
action.
I can issue a notice only today at the most.
Bail application,
BA,
BA.
you are under arrest.
I am under arrest.
So I'll have to just see what is there. At least one day, get it. We'll have it. We'll pass an order, ask for the CD on Monday or Wednesday. Did you get it?
Much of that.
Yes, Mr. Counsel. Wait.
My lordship, the accused person already arrested.
Already arrested. It is submitted by the learned counsel for the petitioner that the petitioner hearing has already been placed under arrest in connection with Runikata Police Station, case number 16/2024, registered under section 447/326/307 IPC, and accordingly he prays that he be permitted to withdraw the present bail application. Prayer is not objected to by Mr. D. Sharma. Learned edition to be accordingly, the bail application stands dismissed on withdrawal. Fake gold. Fake gold.
Fake gold.
How long? When?
From Lakhimpur, Lordship,
50 days, already 50 days.
13.
13. On the third day, Learned Council for the parties issue notice, call for the case diary, list again on 13/9/2024 for production of case diary.
Obliged.
Lordship, medical report will be necessary.
You have not got it.
Lordship.
May I please, your Lordship?
Hmm.
Lordship, we find the FIR, my lord, at page 11, my lord, translated portion, particular portion is page 15, my lord. May I read, my lord?
Get your city. This is,
From
there is a cross FIR also? No. Is there a cross FIR? Civil case? I'm asking you.
Lordship, I have to take instruction, my lord.
No, it's okay. Get your CD.
Lordship.
As on date, my lord, 27 days in custody, my lord.
Be there for some more time.
You
Same,
can become 18.
when?
18.
18/9. Same, Basu.
Obliged.
18. It will be so.
At this stage, my lord, kindly call for the civilian.
Patigaon.
16.
Bike. Bike thing.
16.
16/9.
Obliged. Wait, please, your Lordship. Lordship 439, Lordship is a regular bail application, Lordship 483, Lordship. 16 days, owner of the vehicle, his name is not there in the FIR, Lordship. Page 10 is the FIR, Lordship. Is the owner of the vehicle, the purchase license of the vehicle, Lordship, purchase voucher, Lordship, that is on page 26, Lordship. Is the owner of the Bolero vehicle, Lordship.
What is his name? Rafiq Ali.
Rafiq Ali.
CD will be required, Lordship. Because it transfers, Lordship, there is a whole nexus that is occurring.
One thing Lordship will appreciate, Lordship, the vehicle has been taken to drop from one place to another.
Who is the Masood Hussain?
But Lordship, the vehicle has been used by this Lordship, Rahmat Ali, Lordship, from transporting these two
Okay, when?
passengers.
Lordship, it's from Lakhimpur. 17. Lordship.
few of them has been granted bail by the session court. I should not place it before this court, but few of them has been granted bail also by the session court.
2183.
I have no lordship. I'm not an interim bail lordship.
No,
I'm
no, no.
paying for it.
BA to AB 2183.
Lordship, my AB is 22.
No, 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 the other one.
That is 2183 lordship.
2183. Huh? What is it? Human number. It is said that it is there today.
Lordship, actually on the last occasion, it was said that it is fixed for CD today. That is why this matter was also fixed today.
2183. Down 9. Down to 9. It হয় কিন্তু মানে check up correction registry বা কি আছে we'll take it up after some time.
Lordship. Wait, please, your lordship. Lordship, 12 and 13 out of the same case.
Injury report has been received.
Not received, lordship.
Lordship, 13 can be taken first, lordship. It's a 70 days in jail custody, lordship.
No, no, there was an injury report called for by this court.
Grievous injury is stated, lordship.
No, why the report is not coming?
Lordship, CD was called. We have already communicated, lordship. Lordship may fix a short date, lordship.
10/9. 10/9. CD. Updated CD along with injury report.
Highly.
May I please, your lordship? On last occasion, case day was called for,
Yes.
and lordship, 15, this case was filed earlier, and my case is filed later, so he, firstly, he should submit. Lordship,
CD
although
not
my,
received, lordship.
Not received.
Not received.
When?
From Kolgosia, Borpeta, lordship.
Borpeta.
11, lordship.
11/9.
lordship,
11/9. CD not
oblige, oblige, my.
11/9. CD received,
Lordship, these are motion matter, lordship.
but CD was called for.
Lordship,
Oh, no, not this. Not this. It's called for the CD. Conspiracy. Killing your own husband.
Conspiracy, lordship.
Killing your own husband. Get the CD.
Yes, sir.
Ben.
No.
It is from
Tinsukia.
Tinsukia.
18/9.
18/9.
Lordship,
We'll have to see, Mr.
kindly for petitioner number 3, can it be considered?
Together.
Oblige, your lordship.
PP Botato. List this matter again on 13/9/2024 along with BA number 2569/2024.
In the meantime, lordship.
2569.
Oblige. My lord, I'm another question regarding item number 9, lordship. My lord, it is fixed on 17 for CD. Can it be on 13, lordship? 13, lordship.
Mr. Sharma. 17 CD. Item number 9. It is from
Bongaigaon, lordship.
Bongaigaon.
Item number 9. 13, lordship.
9.
Item number 9, my lord. Item number 9.
Sharma had appeared.
Fixed on 17, lordship.
Yes.
What if you believe the money?
Can it be advanced a bit? He wants something.
13, lordship.
13/9.
Oblige, lordship.
9 to 9.
Well, allegation and counter allegation is there. Our affair is first and subsequently this affair has been lost. Only to realize the money lordship. There is a long affair lordship. Victim was a widow having 12 years child, and she maintained relation with the petitioner. Subsequently, some transaction lordship money.
Your car and all those things were. Yes. What is it?
So, my lord, he is a tenant, accused person is a tenant
in the residence of the.
Both are major, it seems to be a consensual relationship.
Yes.
Shall I give interim or disposal? That option is yours.
Your lordship may also dispose it of also.
Okay, we'll dispose it. M. Khan. P. Bhattakur. Didn't get it. Done.
Problem.
Dispose that. Bail.
Application, my lord.
We have granted bail to the others, but therein we find that you are the main. Huh? But here you are the main man person.
Yes.
No, I am the president, my lord.
Ah, your husband Johor Ali.
No, husband is behind the bar. What the, my lord, this lady is the president, he's.
Let's see her role.
Their guide, their only thing is the guidelines have been violated and the process, the which the app should be, that money had to be transferred, allegation is that has not been done.
You are
Lordship,
involved.
can you see the last lordship order like yesterday?
That is with regard to the others. We have seen it.
These are documentary evidence, my lord. Lordship, everything will be come out. I cannot temper, I cannot even, and then Lordship will, this lady has a 2 kids, my lord. He have to look after it. And husband is behind bar, my lord. Lordship will call for the CDN, but if there is examination thereafter, Lordship will reject him. The only thing is, well,
But here the direct allegation is against you. You
Yes.
have with your husband misappropriated the only.
only the allegation is against the secretary.
This is from Bozali, Patsala.
But this is for
10th.
interim protection, my lord.
10.
Lady, my lord, these two children are there.
10.
My lord,
I've gone
Lordship
through.
will grant protection and free treatment along with the other case, my lord, on 22.
Show me the order, earlier order.
I will appear before them.
My lord, huge amount of public money, 1 crore 60 lakhs, my lord.
No,
and
it's
her name is specifically mentioned. My
Also,
lord.
I will appear and cooperate with the investigation, my lord.
I granted bail to them because they were in the periphery.
My lord, secretary is the main person, my lord. I am just a president because the finance will be controlled by the secretary.
He retired.
See, retired. I am also not in office, my lord. My POD is over. I cannot go and temper anything, my lord.
You are no longer the president.
Okay, Lordship will grant it and fix it on the same day, my lord.
Same 172.
Same 172, man. Same FM.
Okay, 23-9. Interim.
With same condition, my lord. I will appear, my lord.
S. Bora. P. Bhattakur. A2. A. You were the president
The president.
of 104.
He is the ex-president.
এটা লাইন লিখা তাৰপিছত B2B C2C হ'ব. Mr. Bora has submitted that the petitioner herein is no longer holding the post of president of the said Gram Panchayat as her tenure had already come to an end. তাৰপিছত D2D. Noticing that the main accused that is the husband of the petitioner. Hmm. 23-9 interim 7 days statement.
Lordship. Okay. Lordship will, along with the other.
Along with it list on so and so. 40. 40. এই তো 40 লগত মাতি দিব। Along with it, the WTC number 2, WTC number 2. The WPC will be a number 20.
This is the lordship. Except the bail application, my lord.
You are the junior engineer.
Your lordship may kindly come to page 11, my lord,
Hmm.
of the FIR, last portion, my lord. How he is involved along with other two accused persons, my lord. I would like to point out, my lord.
Yes.
The alleged accused number 2, the present petitioner,
Hmm.
reported that one day he had been called by the alleged accused number 3 and that he had been forced to sign the bills pertaining to the above mentioned scheme despite his unwillingness.
Okay.
The present petitioner is the, my lord, junior engineer, and he, my lord, stated before the complainant that despite his unwillingness, he was forced to sign those bills, my lord. And enquiry report page 19, my lord, your lordship may.
I've seen it. We have passed orders yesterday. Similar,
Yes.
similar.
Oh,
We'll maintain that, and we have fixed the matter on 20th
Yes, ma'am.
for 20th for production of CD. We'll
Yes.
have it together.
Yes.
Similar amount. Khali turn on to and Mr. P. Bothakur. Entry
Keep to
7 days,
7.
20 September. Yes, have you got the report? Mr. P. Bothakur, but this is the last chance I'm giving you.
Yes.
Mr. P. Bothakur, learned additional PP, submits that he be given a last chance to bring on record the report from the IO in the matter. So, as prayed for, list again on
19/9.
19/9. Last chance.
Yes.
May I please, your lordship?
Hmm.
Appellate court has dismissed our appeal and upheld the judgment whereby 3 months rigorous imprisonment along with 5,000 fine and lordship 15 days more days in default for more 54 offense under section 341.
What is the error? So, what is the error?
And I am directed to, we are directed to surrender on 10th, lordship. That's why I have filed a miscase.
Where is the mistake?
Lordship.
Yes, what to do here?
I has been filed for suspension of order, lordship, and
Huh?
LCR may be.
LCFM will be suspended for the time being.
Yes.
Heard Mr. G. Chomo, learned counsel for the petitioner. Also heard Mr. P. Bothakur, learned additional PP appearing for the state respondents. Issue notice, returnable 4 weeks. Mr. B. Bothakur accepts notice on behalf of respondent number 1. Also, petitioner to take steps for submission of for issuance of notice upon respondent number 2 by way of registered post with AD. Steps within 3 working days from today. Also, the present revision petition is preferred assailing. Judgment and order dated 27/8/2024 passed by the learned session judge Lakhimpur in criminal appeal number 31 bracketed 4 of 2023. Upholding the judgment and order dated 26/9/2023 passed by the learned judicial magistrate first class Lakhimpur in GR case number 1006/2006. How is it issue notice? So and so, so and so. Huh? Also,
you may be allowed to remain
I-
on previous bail. Yes, sir.
criminal. I'll suspend this sentence.
Yes. And lordship, we may be allowed to remain on previous bail.
Okay, no
Already
problem with that.
Yes.
But Mr. G. Chomo, learned counsel for the petitioner, also heard Mr. P. Bothakur, learned additional PP. The present interlocutory application has been so filed, praying for stay of the sentence passed by the judgment and order dated so and so. Okay? Huh? Also, peruse the material, issue notice, returnable on the same date. Returnable 4 weeks. Okay, steps, copy here, steps and again logo. So, till the next returnable date, the sentence as passed by the white day so and so. Sentence of rigorous imprisonment of 3 months and to pay a fine of ₹5,000 each in default to undergo simple imprisonment of 15 more days for the offence under sections 341/325/334 of IPC shall remain suspended. The petitioners shall continue to remain on previous bail.
Deeply obliged, my lord.
Wait, your lordship. Lordship has fixed this matter regarding one circular, lordship.
We have got it. But here notices have not been issued till now.
Notices have not been issued in this case, lordship. And in my humble submission, lordship, the magistrate could not have passed this order. Did it?
We'll consider it. Yes, what do you say?
My lord, otherwise offence is under charge not yet framed, my lord.
Not yet framed.
Let him, my lord, place all these points at the time of framing charge, my lord. Only
No,
cognizance
that is
taken.
very
with the
different,
trial.
lordship. I'm challenging the order passed by the magistrate, lordship. The legality has to be seen, lordship. And also the charge sheet, how this has happened, lordship. And the magistrate is empowered to take cognizance. There is no dispute in that. But without application of mind, can the magistrate take cognizance? That is the question that has to be answered, lordship. So in my humble submission, notice may be issued, and in the meantime,
No, we'll not stall that. We'll issue a notice. That much I can do for you. And the interim prayer, we will make it returnable subject to appearance of the respondent number 2. Issue notice, so and so. Issue notice, the present application has been filed. Assailing. An order dated.
both lordship 19-1 and also the charge sheet, both.
Order dated 19-1, charge sheet, assailing the charge sheet as filed by the, filed in PRC case number 3/2024 under section 120 bracketed B/143/341/326/302 IPC insofar as the petitioners are concerned, and also an order dated 19/1/2024 passed in the above noted case by the learned SDJ Bilasipara. So issue notice, returnable 4 weeks. Respondent number 1, P. Bhattakur. Petitioner to take steps for service of notice upon the respondent number 2 with registered by registered post with AD. Also, it is the prayer for interim relief is also issue notice on the prayer for interim relief. Same is also made returnable after 4 weeks. Registered to list this matter immediately on completion of 4 weeks from today.
Then lordship, Dusty may be on the respondent number 2.
Take a register.
I'll update.
Yes, Mr. Bhattakur.
Lordship, statement against your lordship, rejection of prayer, your lordship made under section
311, recall of witness.
Lordship. Your lordship, our prayer, your lordship will get it.
The place of occurrence was
Lordship.
not then, but is it not a filling up of a lacuna?
No, your lordship, kindly see your lordship, the question of filling out lacuna will come later. It is not lacuna, your lordship. It's a defense, your lordship, which I need to set up, your lordship. And when it is apparent, your lordship, palpable, your lordship.
Because she has given 2 places.
Lordship. two places that needs to be, and
Well-
secondly, my.
You take advantage of that.
No, that your lordship, unless we put that question specifically to her, your lordship, dispute it, your lordship, that defect may remains, your lordship. And ultimately, your lordship, the ground on which the learned court below, your lordship, rejected my prayer, your lordship. This is absolutely.
What happened yesterday, 5-9?
So, your lordship, it is fixed for statement defense. It is on, next date will be 1st of October.
1st of October. You take steps, we will have it before that. Heard Mr. S. Bhattakur, learned counsel for the petitioner, also heard Mr. P. So-and-so, P. Bhattakur, learned additional people. The petitioner hearing has assailed. By way of instituting the present proceedings, the petitioner has assailed an order dated 6/8/2024, passed in petition number 1058/2024, dated 1/8/2024, filed by the petitioner under section 311 of the CRPC in special bracketed POSCO case number 42/2022. Also, issue notice, returnable 4 weeks. Respond number 1, Mr. P. Bhattakur. Steps by registered post, respond number 2, 4 week, registered post with any steps within 3 days. The prayer for interim relief shall be considered on the returnable 3 weeks could be 3 weeks could be. Also, registry to list this matters again on 30/9/2024. The prayer for interim relief shall be considered on the returnable date.
In fact, your lordship, there is a judgment, your lordship, where Honorable Apex Court very specifically said that when it comes to the unearthing of truth, technically.
The Supreme Court judgment is that if it's the discretion of the court,
Yes, yes, this.
if it is to unearth a truth and to get to the bottom of the thing, it can even permit addiction of evidence or documents. But yesterday I was hearing that matter. But here it also said that there is also a line that it should not be to permit a party to develop the case. That much only I want to. Let the party come, we will hear it.
Deeply obliged.
My lord, the petitioner number 1 and 2, they are husband and wife. They have 2 sons, my lord. One is aged 20 years and the other one is aged 5 years. What happened, my lord? Before 4-5 years, the elder son, he had a relationship with a girl named Soma Saha. At that time, both of them were minors, my lord. And subsequently, they entered into an agreement with the parents of the girl that as and when they attain majority, they will get the marriage will be solemnized. My lord, on 30th, my lord, the girl.
What is there in the video?
My lord,
Video.
but they recorded, my lord. But thing is that lordship will kindly consider, but the age of the boy is 20 years. As per the legal age for marriage of a boy is 21 years, my lord. Still, he has not attained the age of, it was an unfortunate
But let's
incident
see.
happened, my lord.
I know that. Let us see. Let us be very clear as to why.
But
What
only
is the
allegation.
reason?
Well,
If it is only because of that love going,
yes.
then we will be with you. But
Lordship,
if there is something else,
But that lordship will always consider at the time of after perusal of the case diary. But the youngest son, lordship will kindly see at page 23, is studying at UKG, my lord. Well, if they are apprehended, arrested, my lord, then
you are for this present petition is the mother of that boy.
I am for the accused number 2 and 3, father and the mother, my lord. He has already been the boy.
What happened to accused number 1?
Well, he has been taken into custody. Lordship will turn to page 17.
He is still in custody.
Yes, my lord. He
No
was-
bail application filed.
No, my lord, no bail application filed. Lordship, the forwarding report.
Okay.
And he has been
Heard,
sent to
Mr.
judicial
We'll
custody.
protect them. You get this CD.
Lordship.
Yes, my lord. Otherwise, my lord, from that video recording, my lord, that amounts to a dying declaration of the my lord victim.
I know, but here thing is,
So-
these two may be responsible for restraining the boy from marrying,
Yes.
right? And the boy is still not of marriageable age.
Yes,
The boy may be involved. Boy may have done something. We'll see to that.
yes.
But
Kindly
these two are
protect-
parents.
Yes, lord.
Heard Mr. T. Chakraborty, learned counsel for the petitioner. Also heard Mr. P. Bhattakur, learned. So the present application has been so filed, praying for pre-arrest bail in favor of the petitioner, namely Gautam Kumar Saha and Jumki Saha, in connection with Bijni PS case number 121/2024 under section 61(2)/64(1)/351(3)/108 BNS 2023. So I perused the FIR, and therefrom it is revealed that the allegation basically pertains to the accused number one, who is the son of the petitioner's hearing. Also, the allegation against the petitioners who were arraigned as accused number 2 and 3 in the said FIR is to the extent that they have prevented the accused number 1. They have facilitated the escape of the accused number 1 from the area to avoid marriage with the informant's daughter, who had committed informant's sister, who had subsequently committed suicide. Also, on a perusal of it is stated in the bar that it is stated by Mr. Chakraborty that the
And while order dated 38 at page 19, he was sent to judicial custody.
30 or 31?
31st. He was arrested on 31st.
31st.
Yes, FIR on dated 38th.
31st, 31/8/2024. Full stop. In view of the above position, I'm of the considered view that the custodial interrogation of the present petitioners may not be necessitated at the present juncture, and accordingly, it is directed that in the event of their arrest in connection with they shall be released on bail of rupees 30,000 each, with like surety to the satisfaction of the arresting authority. It may record Kuribo. Temper no kore. 18 condition no very good.
I'm deeply obliged.
Okay, when fix
24/9.
fix on so and so 24/9. Upward issue notice call for the city.
Obliged, Lord, sir.
24.
Can it be possible for the time being, your Lord?
Going.
Mr. P. K. Roy Chaudhary Sarul.
Huh?
Mr. P. K. Roy Chaudhary Sarul address.
My lord, they are not paying any maintenance. His past
They'll have to.
judgment of the court also, they are not paying.
You'll have to
any.
payment.
They should clear the dues first, my lord, then the fight. Moreover, second revision, usually
Yeah.
don't entertain, my lord.
I'll not go for the question of marriage, because in the rape case, you were acquitted because of a finding recorded by the court that you were married.
Yes.
No, that the court has taken a presumption from the petition.
Be
filed
that
by
as
her.
it may, be that as it may,
It is the petition filed by her.
be
your
that
Lordship.
as it may, for the
On-
time
on
being,
two
clear the
occasions-
dues.
On two occasions, two different things they are stating.
You get Mr. Roy Chaudhary. Let Mr. Roy Chaudhary come here. Yes, Mr. Soikia, both of you. Anything you're sitting, any matter?
I have one matter, my colleague,
25.
existing counsel is not here.
Okay.
25, I can.
Oh, it's coming, it's coming, it's coming. Take 2 minutes.
Yes, yes.
2 minutes.
Well, I am preparing for the respondent lordship. Lordship petitioner,
Any settlement?
no lordship petitioner did not pay any,
None appears for the petitioner on call.
20% also.
Of
not
the
due.
compensation was directed to you. Okay, let her come. We'll see on nobody. Raise it to Elizabeth's matter again on. Eleven 9.
Lordship, in the meantime, compensation may be paid, 20% lordship. As
Well,
directed by
they're
the
not
court.
there, but that's not passing rules. Yes, Mr.
Yes, Lordship, this is the application filed by us, Lordship, under Article 4, Section 482 of the previous Act for setting us aside of a search sheet, which we have not obtained till now,
Hmm.
but the second FIR.
Hmm.
If Lordship is pleased to look at my prayer.
Somebody had heard this matter.
Lordship,
This matter was heard.
yes, earlier it was heard, but interim was granted, but it was.
Interim is on.
Interim is on, Lordship.
Mr. Sige, you're on an interim.
I am on an interim.
Scan copies have been received. But this will have to be now finally disposed of.
It has to be finally
Yes.
disposed of.
Hmm.
And one order, Lordship would like to see 8/5/2024.
In our order.
Yes, Lordship.
Huh.
Hard so and so, second line. The learned counsel for the petitioners prays to provide him the copy of the charge sheet and statement of the witnesses recorded under section 161 CRPC. So charge sheet we applied before the court below. It was not given because it was submitted, but it was not accepted till now.
Oh,
And number two, the witnesses statement, because what is the basis of our case? One FIR was filed against a particular officer, and there are a lot of companies involved. Thereafter, another FIR was filed against the same officers, and our company was also included. In the first proceedings, Lordship, we are giving our statements, we are participating in the first FIR's process
Hmm.
investigation. In the second, there cannot be any second FIR on the basis of the
that will
same
be,
event.
that will be.
That is a settled position of law.
Hmm.
The Lordship may look into those documents today, but ultimately what we have to convince this honorable court, that is why the LCR was called for. The
LCR
search
has
sheet we
come.
have to see. to
LCR
complete-
has come. You
Yes.
can go to, you can ask Mr. Fukan, Ms.
Or
Borua
else,
to-
Lordship, because that direction was given to them to hand over our copies, but this was not written.
There was no direction. It was,
Yes,
it was a prayer. Your submission was recorded.
Yes, submission was recorded,
But
and
no-
it was understood that day that it will be given to us.
My lord, question is whether they are entitled.
I
for
will not
this copy.
speak anything wrong here.
Whether they are entitled for this copy from this honorable court in 482 laws. That is the first question. They could have obtained those documents from trial court.
But they say they have applied, they have not been given.
Lordship,
What to do now?
Lordship, it's a quashing of the FIR, Lordship. Will confine to that, whether this honorable court will go through the roving inquiry of all the documents which were seized and.
The law is settled. Even if a charge sheet is filed, the FIR can still be quashed,
Yes,
can be gone into.
yes.
Okay, let us leave all this thing. We'll, Mr. Soikya.
Lord.
Let us go for the final hearing of the matter. Final hearing, whenever it's nothing here, because now it's all vacation coming, it will be on a holiday mood. Let us have it after the pujas on a date to be fixed, we'll finish it off.
Lordship may start the hearing. No difficulty.
No, I don't know. I may not be in this bench for a long time.
Because
This will take some time.
it will take some time.
It will take-
Lordship may start today and let it continue after the vacation.
Stays there, Lordship.
That's what I said. We'll give me a date, we'll fix it for
Corruption
hearing.
case, Lordship.
Huh?
Corruption case, Lordship.
Corruption case, but the issue is also to be looked into. What is the issue?
Correct, Lordship.
Second FIR.
Correct. Second FIR.
But I am reiterating my prayer again. That search sheet copy, at least I am entitled, and the statements of.
You ensure that they get it from the lower court. You have filed it. Why is the copies not,
File.
why is that copies not being given them?
Charge sheet has been filed, perhaps it has been called for, therefore. it's
That
given
you
here.
forget what has come here. From here, we are not giving it to them.
Lordship.
But the thing is, why is the lower court not giving, the
That I
trial
need to
court?
take instruction, Lord, file here. Charge sheet thing. I have not any.
You have filed your charge sheet,
Yes, yes.
then why the further process, there is no stay?
Section 207 is there, they will get the copy from the court below only.
Huh?
So I
Then
don't know
let
what-
us
Then
apply
because
their
you
Lordship
say-
will adjourn this matter.
You apply it from there
Yes.
and then you get it. That would be the,
Yes, Lordship. In that case, Lordship may give some indication, observations in today's order.
Mr. D. Saikya, learned senior counsel appearing for the petitioner, has submitted that the charge sheet has been filed in the matter, in the proceedings before the trial court. However, a copy thereof has not been furnished to the petitioners. Also, Mr.
We would also like to request for giving us the copy of 161 statement.
And also the charge sheet along with its enclosures. has not been furnished to the petitioner. Mr.
Lordship, I have one submission. Lordship, the proceeding was stayed. They are entitled for the copies under section 207 only when they appeared. They didn't appear, Lordship. The stage of appearance is not yet complete, Lordship.
Oh,
There cannot, no. The thing is like this, Lordship. That is for the trial purpose. We are not in the trial now. If only this honorable court allows and comes to the conclusion that the second FIR is maintainable, then only the proceedings will go. But as they have already submitted it, we are entitled and we have to make our argument and convince this honorable court.
no,
that both the
Mr.
facts are
Sakia, why
similar.
do you require the charge sheet for that purpose? You can always rely on the materials which is there.
Those materials, certain materials will be helpful to us.
Helpful, we have it here in the
And
time of.
otherwise, why Lordship has called for those records?
No, that we will peruse. If you find something, we will peruse that because we have called for it,
That
we'll
is
peruse
why.
it. We
If
can.
Lordship, if this honorable court will have some basis of the materials which were already called for before this honorable court.
That material,
And they have the access, they are the privy to those documents.
I know that.
So.
Mr. Soikia, you got to make out a case. You got to make out a case with regard to the second FIR.
Second FIR,
You will have to establish that that second FIR is actually a second FIR, not maintainable.
not maintainable.
They will try to say that it's a distinct offense.
In that view of the matter, the honorable court has called for the LCR.
We have everything with us. You continue, you make your submissions on that, you develop your submissions on that. We will refer, and if we find that it is also to be
Seen by us.
seen by us, we will find
So
out if can be
initially,
done.
That
Right?
was not our prayer. Initially, that was not our prayer, but our prayer was that when LCR was called for before this honorable court, then definitely we do not have access to those documents.
You will not have it today.
Yes.
Let the hearing go on. In the hearing, if we find that we have to give it to you, why? Fairness. We are only trying to
Yes.
resolve an issue.
Because nobody should be penalized without.
Because
the
my
principle of
view-
natural justice.
Mr. Soikia, subject to correction, my view, given the issue arising herein, it has to be confined to the issue of the FIRs. only.
Absolutely. On
That
that
part-
basis only, on that basis. only
Subject
we'll
to correction,
consider.
that part need not come in now.
That
Okay,
is why we have, what is our prayer? Setting aside the.
we have seen it. I've seen
Yes.
it. I've seen it. And we'll stick to that, Mr. Soikia. You satisfy us on that point, we'll hear them and then we'll proceed with the matter.
Then after vacation.
Continue. Heard Mr. D. Soikia, learned senior counsel, assisted by Mr. M. Fukan, learned counsel appearing for the petitioners. Also heard Mr. M. Haloi, learned standing counsel CBI, appearing for the for the respondents. The LCR has been received. Accordingly, the learned counsel for the parties submit that the matter be taken up for final disposal.
No, Lordship, my humble submission, that issue, if required, because today Lordship is taking up. If Lordship is taking up the matter after vacation, I have no difficulty. Lordship knows, and
Okay.
whatever has fallen from Lordship's not. In that, no further hearing may be given.
I'll do it. Matter be taken up for final disposal. Also, accordingly, register to list this matter. When? Give me
Immediately
a
on
date
the
first.
opening.
Huh?
Immediately after vacation, Lordship.
Say 22nd or 24th?
24
24th,
for further hearing.
24th, no, 24, 10, 2024.
October.
Also, the LCR that has been so called for. Also, Mr. Saikia submits that the LCR has been called for and this court would like to peruse the same if the occasion so arises, and accordingly he submits that he be also given an access to the said records LCR to make his submission if the occasion so warrants. Also, this aspect of the matter would be so considered at the time of final hearing of the proceedings, and if the occasion so arises and if it be permissible under law, this court would permit would consider the said prayer of Mr. Saikia. Registered to list this matter again on 24/10/2024 in the admission column with the understanding of the admission column in the admission column. Bus
Deeply. obliged.
24/10. Because I don't know where I'll be.
Then I understand, Lordship. Only because that, whatever has fallen for the next judge.
Because
may
Mr.
not have
Soikia,
that-
subject to correction, here the issue is not with regard to a challenge to the charge sheet.
Absolutely.
It's with regard to
As
the,
because the LCR was called for, therefore this subsequent argument on our side, Lordship, developed.
My lord, LCR has been called for as paid by the counsel for the petitioner. Lordship.
Mr. Haloi, these are things which goes with the flow.
Right.
Mr. Saikia is within his rights to make all arguments. You are also on right. But what is to be done, we will do when the matter. Here the issue is FIR.
Correct. Lord.
Why should we break ahead with the charge sheet?
Correct.
And that too, it's
Only-
in a very good red cloth. Let it be in the red cloth tied up. We will see the FIR. If the FIR, something comes up, then we will go.
Highly obliged.
I'm enjoying it.
We too, Lordship. And when Halay is there, the fun is more.
He's a master.
Absolutely. Lord. We have to be always on the defensive
Depends.
and sometimes also slog over is required.
So
The
give him
other
some
day, Lordship,
walkovers
he appeared.
sometimes. Sometimes you give him some walkovers.
Correct. Lord.
The Lordship, the other day he appeared with both his hands broken. So we thought he will take time, but he was
No.
standing in front of his home camera
Uh,
and he was showing both his hands.
Mr. Haloi is, he
I
smells.
thought this is not Paralympics.
Now you're okay. Answer
Yes,
fine.
yes. Hello. My lord, in this case, my lord, LCR received,
Hmm.
but I have not gone through the LCR. My lord, some time may kindly be allowed. Because against the framing of charge under section 21C and 29 of the
Hmm.
NDPS Act. My lord.
There was no seizure from his person.
Yes. Heroin, my lord.
Heroin.
726.
Mr. Chaudhary, when?
My lord. This is quashing, my lord,
I
of
know.
the criminal proceedings in NDPS case, my lord. This petitioner, my lord,
No, he wants to go through the LCR. Let him go through the LCR once.
he is behind the bar, can it be a short date, my lord?
Whenever it's small issue.
Can you sort that on Tuesday or
Tuesday? Thursday.
Thursday?
Thursday. 12. At the Learned Council for the parties as spread for by Mr. P. Bhattakur, learned additional PP, who submits that he be given a week's time to peruse the LCR and to make his submission thereafter, registered to list this matter again on 12/9/2024.
My prayer for Jimma of Aragonat was rejected by the learned court below.
Bittlenut.
Yes.
Better
One last such may be allowed, report not yet received. My lord. On 19, I can produce the report. My lord.
Give little bit earlier. This is a matter subject to decay.
On
I only want a submission from you. He has brought in all the requisite documents
Yes.
on record.
Yes.
E-way bill, GST, everything is on record. The source. If you have any doubt on the source of that material, it is being emanating from Myanmar,
yes.
come out with that. Establish that, get the thing cleared up. Otherwise,
Yes.
the matter has to be done.
Yes.
If he is procured the material from Nagaland
Yes.
or from the Northeast,
Yes.
and then he is transporting, you can't stop him.
Yes.
But if you suspect that this matter is from Myanmar,
Yes.
that would be a different issue altogether, right?
Yeah.
But that aspect is not there.
Yes. On 12/9.
As prayed for by Mr. P. Bhattakur, raised it to list this matter again on 12/9/2024. So no further adjournment in the matter would be granted. Mr.
Alright.
Bhattakur shall produce the case records, case diary, along with the report.
Only report to me.
Or along
City
with,
and
shall
national,
produce
city
the
and
report of the I. In the matter. Yes, what is that?
I have the report, my lord, and with photographs. Building has
No,
been
forget
constructed-
it. I don't want that. I just
Building
want,
has been constructed as per the NOC, even occupancy certificate has been granted.
that much is enough for me.
That's-
Yes. Now I'll permit you to withdraw. Mr. S. Bora, Learned Standing Council, GMC, GMC or GMDA, GMC submits that he has received instructions in writing from the authorities that the building in question was so constructed in terms of the plan approved by the authorities, right?
Lordship.
And
Even occupancy certificate has been granted.
and thereafter occupancy certificate was also issued in respect of the said building by the authorities of the Guwahati Municipal Corporation. Full stop. In view of the above position, Mr. P.K. Das, Learned Counsel for the petitioner, reiterates his prayer for withdrawal of the present writ petition. Prayer accepted. Writ petition stands dismissed on withdrawal. Okay. You have any communication?
Lordship.
The written communication received by Mr. S. Bora is kept on record and marked as X for identification.
Report, photographs, occupancy certificate, everything.
This will do.
Okay.
This matter, my lord.
Charge sheet submitted. Yes, charge sheet submitted.
28, my lord.
There is an idea.
No, my lord, regarding submission of search sheet, my lord, I have no instruction. regarding
Why?
that.
You receive your instruction already. We'll take it up at 2 p.m.
Yes, my lord. So,
Oh, I'm allowing him to go.
yes.
I fixed it for that purpose only. Today is the 90th day.
Yes, ma'am.
Fine.
May please, your lordship.
Hmm.
The 302 case, I'm in custody for 80 days, my lord. The dispute between me and my wife, prompting my wife to leave my house.
My lord,
I went to bring my wife. A scuffle took place between me, my brother-in-law, and my father-in-law. In the course of
And
the scuffle,
my lord, in
your
this case-
thing is that it is the father-in-law who held you and the blow
and the
from
brother.
your brother
Hit.
fell. But what does the CD say?
Yes, well, I have received the case diary.
Ah.
In the case diary, my lord, postmortem report is not available. Otherwise, my lord, eyewitness is there implicating the present petitioner. He also in fact
Scuffle
admitted.
was there, my lord. That is, we are admitting, we are not disputing that part, my lord. Scuffle was there. And
So how long have you been in
80 days, my lord.
registered to list this matter again on (13/9/2024) CDB retained. Full stop. The postmortem report has not been received.
Not received, my lord.
Why?
I talked to the IO, my lord. He tried to collect that postmortem, but till now, my lord.
Mr. Bhattakur shall place on record the postmortem report on the next date along with the case diary. The case diary receipt be retained.
My lord has received on 13th.
13th.
Deeply obliged.
So by the time it will be around 88 days,
87 days.
we will permit you to go.
That is worship, my lord. 34, 39, earlier,
30 given?
72 days, my lord.
30.
30, 31 AB, 30 is BM. Father and 2 sons. And the rest is all the 3 sons of this petition number 1. The lordship will find your lordship page 10. Six person named in the FIR.
Yes, have you got the case diary?
In fact, my lord, there is a relation that is.
Report is not available in the case diary. But statement of the injured person is available in the CD.
Hmm.
Well, he implicated 3 persons, my lord.
Hmm.
One, Kosar Ali, accused number 2.
Hmm.
Accused number 5, Nur Mohammed SK, and accused number 6, Nur Hussein SK.
So all the 3 petitioners have been implicated.
Item 30. They are in custody for last 72 days, my lord. And your lordship had cross case also there, man. What happened, my lord? Dotaka petition number one.
Cross case is at page 18.
Yes. Yes, madam. My daughter, my lord. In fact, relation now, matter also settled, my lord. Marriage also going to take place now. And affidavit also there. After a long matter, condemnation.
And what is the other case?
Other case, any of the three sons of petition number one. Other three sons, my.
Injury report is there.
No, well, injury report is
No,
not
it is not injured, my
available
lord.
in the book.
I think so. Injury report, my.
Injured person implicated all accused persons of item number 30, man.
And what about this?
31 accused person, injured person not implicated.
Nurul Azim and Ashidur Sheikh not implicated.
No, 31, item number
Item
31.
30 was not implicated, he is saying.
So 31 will allow them.
Yes.
30 also matter for 72 days, my lord. Already settled. There is
And
a-
what about 30?
30, my lord, injured person implicated all these accused persons.
Injured person is now back home.
Yes,
Yes,
Okay, 72 days.
yes.
Length of
already, my
custody.
lord, and it's settled also, man. Settlement also done.
That we will not.
And their
That is, my
statements,
lord, that is not compoundable otherwise, man.
statements are also recorded by the IO, my lord.
Hmm.
Whether they are on interim or not, my lord, that is not reflected in my file.
So injured person implicated them. And here, nothing. What are nothing in AB, na? AB against them, nothing is there.
And there is no
No material, no
injured
incriminating.
person not implicated.
Okay, we'll pass the orders at 2.
My subject is setting a CGM South Shalmara.
CGM,
30.
CGM, South Salon.
CGM South Shalmara.
You cooperate. 2 o'clock, second half we'll pass the
Mother,
orders.
he will be here, madam.
Yeah, you need not be.
Mother, I am having some problem this second half. I am another item.
There is that criminal case. Witness number 1, 3, 5 and 7.
My lord,
That criminal 376 appeal.
oh, appeal.
You wanted to argue it today.
If you also argument, you will Hojad Lord sitting next to it, my lord. But today,
It will be before somebody.
Friday, I am having some.
No. You please go ahead.
So in that case, any day, next week, any day, my lord.
I was today ready to.
Ready?
No. I had done my notes. I liked it. A very thin case for you. A very touch and go matter. Have it on some other day. Don't worry.
So then, next Wednesday, my lord, if possible.
I'll put it on this day.
42.
Same issue like the one you were arguing
Yes,
yesterday.
yesterday, man.
Nothing.
Your lordship take a matter, my Mr. Ahmad is here. man.
No.
If I am not there, he will be there. Man.
Nothing is there. I'm against you till now.
No, I don't think your lordship will win.
Only witness that is supporting you is that Gaubura. But again, respondent
said no meeting. was held.
number
Five.
PW 5
Five
contradict.
says, by the Gaubura says, I do not know anything.
Okay.
She says there is a meeting.
Meeting and in the cross, she is more emphatic.
That is there.
In your cross, you
I saw
made
your lordship mind will be changed, man.
try. Some we'll have it on some other day.
Number 32. Final report na start sheet. Final report. Hello, in this case, final report submitted.
FR.
FR.
Mr. None appears for the petition on call. It is submitted by the, he has to be released now. He's released or what? No. He's released. When was it submitted?
Yes, submitted on my lord 11, dated 28/8/24.
28/8/2024.
For which my lord petitioners not yet appeared.
We'll say if not released, release forthwith.
Yes.
Mr. P. Bothakur, learned additional PP. submits that the FR in the matter has been submitted by the police and accordingly the detention of the petitioner
Yes, case number one.
in connection with
This, my lord, order may.
Huh.
Copy may be kindly be the part of record, my. Yes, number 64 to 2 है.
has been submitted in so and so. May Bothakur on instructions submits that the police on completion of investigation in connection with Jogigopa PS case number 129/2024 under section 64/305 bracketed small a /351 bracketed 2 of BNSS 2023 has submitted FR before the court of the honorable learned subdivisional judicial magistrate first class North Salmara Abhaipuri. In view of the above position, the further detention of the petitioner herein would not be called for, and accordingly it would be the direction to the subdivisional judicial magistrate or the chief judicial magistrate. Accordingly, the chief judicial magistrate, which one would be? It would be Bongaigaon.
Yes, ma'am.
Sure.
Jurisdictional court.
That would be the SDJM and not Salmara Bhaipuri.
The SDJM subdivisional judicial magistrate first class North Salmara shall forthwith release the petitioner from custody if not already so released. The instructions as furnished by Mr. Bothakur is kept on record and marked as X. Disposed of. It would disposed of it.
Please, Your Lordship. So it's a rape case, I'm in custody for 61 days. Our contention, my lord, is that this. Hello, I'm in 35. Hazrat Ali sir.
You are on interim.
Yeah, no,
two
out of 10, two only.
Two have been arrested.
9 and 10, my lord.
Already in the whole case, my lord, the 4 has been arrested. Whole case.
Now in Hazrat Ali Sheikh, how many are left out? One, Nagesh Ali, Sakina Bibi. Two.
Ibrahim Ali and Nasir Ali were arrested in my petition, my lord.
No, this bail was given in respect of 2 persons.
10 and 9 and 10, they are the parent, my lord.
So bail given to 9.
9 and 10, parent. All the allegation against the FIR name accused number 1. I have not filed his case against his my lord. He is in jail, man. First he was arrested. FIR, you will kindly see at page 11, my lord.
Yes, what is the material?
Till date, postmortem report is not available. Now, one thing is that, my lord, on that day, my lord, at about 3 a.m. night, she was taken from her house by
accused number 1.
accused number 1. This is not before us. Then have physical relationship. Then she pressurized to marry in a short death. All the family members are refusing her from early days. There are
This matters again on 16/9/2024. Interim order passed in AB 2121/2024 shall continue till the next date of listing.
on my lord, on
8/34/35 same.
I am for the informant lordship in item number 35.
on 18, my lord.
We heard.
My name may be shown, but I have some.
Your name is not preferred. A name of Mr.
F.
M. Hawk. be reflected in be reflected in the cause title, cause list. In which item? Item, which item? 35. In item number 35 as the learned counsel for the informant.
Develop. Malam fix on 18, malam
16.
16.
8 to ekalagi. 8, 34, 35. 8, 34, 35.
36.
May I please? 54 days behind the bar. Possibly consent was there.
Small girl, a house help. Hmm. How old is the victim?
She is lordship 19 years. 19 years.
Anything with regard to consent? Her statement has been recorded.
Yes, lordship. CC camera was there.
Hmm?
CC camera was there.
It's inside the garage. How will the CC camera catch them?
Campus.
Uh-huh.
May I please your lordship?
Hmm.
My lord, petitioner is behind the bar about 33 days, my lord. Actually, my lord, on the day of the alleged.
What is exactly the, what is there in the CD?
Lordship, here, as Lordship has seen the FIR, she's a lady imparting tuition.
I want to know what was the tablet she was trying to.
Tablet, Lordship, that has been sent for FSL report has not been received. But Lordship, one thing is to be seen, she has denied that she did not give any tuition. She has admitted that I was feeling sleepy. I did not want to take tuition, so I asked them to sleep with me. So
Why? That is what something very.
yes, but she has not denied anything. Lordship.
No.
Now the children, Lordship, all are 14 years of age. Everyone's 164 has been recorded. They have all consistently stated the same thing. We went for tuition. Ma'am said, today no tuition, you take this tablet. She forcibly gave tablets to some of the kids. After that, Lordship, they were unconscious.
Why that? What is the
It's-
name of that tablet? The name also is not there.
Tablet's name, Lordship.
Hmm.
One tablet name, Lordship, I have found somewhere. But it has been sent for FSL, Lordship, just.
And you have also not said anything in the.
Nothing.
I'm very confused with why. Why this?
What five?
Actually, my lord, as per my.
Any bad thing
Orange
done with the
tablet.
children, Mr. Sharma?
No, no, Lordship. But Lordship, the thing is, Lordship, they were admitted to.
No, why what is the offense actually?
No intention, my lord, nothing is there.
Offense, Lordship.
Why tablet was given? Why water was given?
Even I was puzzled, Lordship.
Because the FIR is to that extent only.
That extent, Lordship, but Lordship, subsequently their health deteriorated, Lordship. They had to be given
That is
saline
fine.
water.
Why was that tablet given?
The motive, Lordship, at this.
What
stage,
does the children say?
164, Lordship, everyone says the same thing, Lordship. Consistent.
The name of the tablet, no way.
No way, Lordship.
Vitamin D tablet. কমলা রঙৰ tablet খাব দিয়ে।
It is the problem, in fact, Lordship, the motive is not clear. Why was
Why?
it?
That is what I want.
That perhaps it was a sleeping tablet. She herself had taken it. She also gave it to the children.
মই টেবলেট খাই সেন্সলেস হৈ গলো তাৰ পাছত হস্পিটেলত সেন্স আহিল
Yes.
মোৰ
And
ক'ব
one-
লগা ইমানে
One of
what
the,
is the offense
one of the boy also urinated, Lordship, he could not control it, and they have to be given saline water, they have to be referred to GMCH.
গুণগুণ ধৰি আনিছিল গুণগুণে টেবলেট খোৱা নাছিল মুণ্ডাছ আৰু জগন বমি কৰিছিল সুগঞ্চিৰ আৰু মুণ্ডাছ get me the name of the get the what is that exactly the tablet for hmm?
One, two, three.
Because I don't find any offense being committed here.
Otherwise, Lordship, 123 has been,
In order to attract the section 123 present section, my lord, there must be intention, my lord. There is nothing, no intention.
What is 123? Just show me.
120 causing hurt by means of poison, etc., with the intent to commit.
That motive is not there.
let the matter be investigated for a few
So
months,
immediately
Lordship. At
to the
least
nearest
the report may
hospital.
be called for, Lordship. Medical. at least
On the Mr. B. Sharma, learned additional PP has produced the case diary in the matter. On perusal of the case diary, it is not evident as to the reason why the accused petitioner herein had given the purported tablets to the children. The names of the tablets given is also not evident from the perusal of the case diary. The IO shall submit a report in the matter as containing the names of the tablets so given to the children and the use of such tablets. So list this matter again on 10/9/22. We'll see it on 10. But very surprising, nothing is there on the face of it.
On the face.
Supplementary course, please. The bail hearing BA item 76.
My lord, already charge schedule was submitted. You were 158 days today.
Hi, you have got it.
Further custody, I am only on that at this stage, my lord.
Lordship, this is scan copy, Lordship, but
And the boy of
it is
21
not shown
years,
whether
sir.
the scan copy has been received or not, Lordship.
No, not received.
Not received, Lordship. As per cause list, not received, Lordship. So another date has to be.
Oh.
On last scene.
Seen the office date dated 5/9/2024. The scanned copy of the case diary that was so called for has not been received. Register it to forthwith requisition the copy, scanned copy of the trial court records
It is here, my lord, Guwahati.
from the list this matter again on
What date was here?
11/9/2023, 2024, along with the scan copy of the LCR as called for.
Regular bail application. The informant seeking
Lordship,
protection.
charge
for
sheet
her
submitted.
Grandmother.
Charge sheet submitted.
Charge sheet submitted. And what about the condition of the grandmother?
CD, Lordship, only the report regarding the charge sheet has been received, nothing else.
That will be required. Because here again, the charge is allegation is very here and touch and go matter. I just wanted to know, I had made a specific observation. I wanted to know the condition of the grandmother of the informant.
That Lordship has not been received.
You see the order,
Yes, the health condition of the grandmother.
Professor?
See the case diary and the health condition of the grandmother was called for, but now, my lord, they have already succeeded on, my lord,
31(8).
31(8).
Under section?
Section has not been mentioned, Lordship.
Charge sheeted on which count? There are two aspects here. One pertaining to the grandmother of the informant, and another one to her father. Petitioner is the stepmother. Now, in which aspect she has been charge sheeted? Suicide of the
My lord,
father?
my lord, I'll
Get
take
the
it,
clarification
At two, my lord, I'll.
at 2. No, you have it on Monday. Or two, season beer per, at two.
Lord, in this case, CD was called.
Ah, yes, Mr. Professor.
This is the city lordship.
No, what is that?
In the city lordship, this person has been arrested lordship and he has submitted lordship that he knew that those vehicles are of police vehicles. They were while police.
I want to know the police action.
Lordship.
How the police left these vehicles there without scrutiny or being monitored?
Lordship, as per that is not actually clear lordship. That part is
I
not
want to
clear.
know that. That is what exactly we want to know. How can a man just walk in and start cutting those?
Because of
days.
as there is no space for keeping those seized vehicles, they used to keep it in that place lordship, that tribal hunger field lordship.
Ah.
And those vehicles are kept there. And whenever someone comes with the Jimma petition, they handed over the vehicle lordship. But lordship, these and those are kept since long time lordship. Since long time, those are kept.
How many
here, lordship.
vehicles have been destroyed by the petitioner?
That cannot be ascertained because there's huge number of huge number of vehicles will be there.
I want to know how the monitoring was not done, how he could walk in. If there was not complicity from your end, how could he do it? I'm not saying he's done a great thing,
No,
but
see,
without
actually what
complicity
happened-
from the police, from the under the nose of the police, these things have been done from the police station.
This is not the nearby. It is 300 kilometers from the.
So you just leave it there and you
They
forget.
have done it within 10-15 days. They have done it, lordship. And
That's
the
right.
police is also
Okay,
not.
Mr. Chaudhary was on a question of 5 days. Now you are giving them 10-15 days when this action is done. Why it was not detected? I want a report on that. I want a report on that. Maybe but I will not, we are not with Mr. Chaudhary. Don't worry about it. But I want to know how this thing could happen. Unheard of. You get a report from the IO. Mr. Chaudhary, wait for a few days. Till Monday, Tuesday.
My Lord, will kindly permit me to read 2 paragraphs from my petition, my Lord. Page 7, para 4, Roman 4. The co-accused Forest Dole father stated, Mir Hussain, in charge traffic branch of Potasi Lambare police station, had specifically stated to him that there is an order passed by the police department to dispose of the old vehicle which are kept in the field. The co-accused Forest Dole had also shown a copy of the order in his mobile phone. Hence, on a bona fide belief, the accused petitioner shows his intent to purchase the scrap of the vehicle. The price was fixed at rupees 3,90,000 after negotiation. The accused petitioner paid 3 lakhs in cash, an amount of 90,000 through internet banking to the co-accused Forest Dole. That the accused petitioner states that cutting, loading and transportation of the scrap of the vehicle started on 8/7/24 in the field of the Tribal Development Authority and continued till 13/7. Entire exercise was carried out for a total period of 6 days in broad daylight. However, none of the police officials had either questioned the accused petitioner, his man, agent, laborer, or had tried to stop.
Mr. Chaudhary, sorry to disturb you, interrupt you. Page 21 is your trade license.
Yes.
You are involved in the business of disposal of old cars.
Yes.
So you know what scrap purchase actually is.
Yes.
Why did you just walk in and start cutting?
No, my lord, that later was shown, that order of the police department.
And the
submission-
money that you have paid to
No,
the.
my humble submission is very simple. Now, in this case, there is nothing further to be, recovered, my lord, because I was sent to jail custody after my initial remand period was over. Now, my only humble submission is, my lord, the consequence of believing these people I'll face in law, I have to face that. Only thing is.
But
my lord,
before that, wait
is
for a
my-
day.
Is my father custodial interrogation.
May not be required, but
Yes.
just give me, I'll give them
Tuesday,
one,
Lordship.
what, Tuesday? I
Yes.
just want that report.
Lordship,
Yes.
apologize, Lordship, I apologize, Lordship.
My
That
lord,
has
this
been done,
police official who has given the permission, he has no action has been taken against.
that cutting has been done, Lordship. I was wrong, Lordship. It was done from 4th July to 7th July. Within 4 days that has been done, Lordship.
But be that as it was done under your nose.
Yes.
But Lordship, when there is a seal gate, Lordship.
That
we-
I want it. It's not there. I want it on a report.
Lordship.
I want to know the complicity. If the story is correct that some police officer had asked it
Huh.
No,
to be
Lordship,
done, then why should this
as per
citizen?
his statement, he has stated, Lordship, that IC has instructed him to do that. But when on interrogation of the IC, Lordship, he denied that allegation that
That is different thing, but there should be something more. Mister, get a,
So why the IC has not been arrested?
this police traffic
Because this-
inspector, not the traffic in charge,
Ah.
Mir Hussain.
Lordship.
He has been
Not Lordship,
interrogated.
because he has stated, Lordship, that I never give any permission, Lordship. It is their
And
statement.
was that mobile phone wherein that order was there, was it seized?
No, Lordship. His phone has been seized, Lordship. That there is no any orders like that, Lordship.
Like that.
And
No,
he
the
himself-
Paresh Dole is from.
Paresh Dole is the person working in that tribal sangha, that office, Lordship. And he has purchased it from that person, Lordship. And he has given 4 lakhs rupees to that person, Lordship.
Okay.
Wow, he has got that authority
Heard
to-
Mr. Ken Chaudhary, Learned Senior Counsel, assisted
Yeah.
by Mr. T. Diori. Also heard Mr. K.K. Parasar, Learned additional PP. The case diary has been produced and the same has been perused by this court. Also, however, the case diary does not reflect the fact as to how the petitioner hearing could proceed to destroy the vehicles, cut the vehicles vehicles which is purportedly seized, which are purportedly seized vehicles by the police and kept at a complex of the Tribal Development Authority without the same being noticed by the police personnel.
Which is adjacent.
It is police personnel, full stop. Further, the petitioner's contention as that he had proceeded to commit the said act after being apprised that there is an order passed in this matter by the police department to dispose of old vehicles. So the said aspect is also not reflected to have been considered in the case diary. Mr. Parasar shall apprise the matter to the IO and the IO shall submit a report along with the case diary on the next date of listing covering the above aspects of the matter. So list this matter again on 10th or 11th.
My lord,
When?
Definitely.
11/9/2024. Wait till 11.
it's okay.
There's a name, maybe kindly corrected, Lordship. PS
Huh?
law follows.
Oh, PS. Oh, sorry. KK Parasar.
A
PS.
copy of the order may kindly furnish to me.
Uploaded today itself. Now only. Upload kodi bhai. Because Mr. Lockhart, be very careful. How can a police area person just walk in and cut? This is something which is troubling me. There may be a bigger scam. I want that.
CDB retained, Lordship.
CDB retained.
Anticipated bail application, Lordship, the petitioner is on inquiry. Here, love affair was there, therefore, father of the.
Yes.
child. And in fact, if your Lordship see page 19. She in fact filed one application before the Chief Judicial Magistrate also, informing all those things that there was love affair, her marriage was solemnized by her family member against her will. All those things are there, page 18, Lordship may kindly see. And
After
in
few
terms
minutes,
of
we'll
interim
examine
order,
it.
as per my instruction.
After exam, so my lord, after few minutes.
After some time. 2 o'clock.
After some can it be, Lordship, at 2, Lordship, I have one division.
Mr. Bhaskar is here. Yes, Mr. Bhaskar, what is that?
They have already appeared, Lordship, and it appears to be a.
Love affair gone.
They have already conducted court marriage, Lordship.
Court
According to the
marriage?
statement by the victim, girl.
She is 18 now.
Yes, sir.
Okay. If there is material that they have done court marriage, No. Huh?
The girl, Lordship. Only the statement of the girl, Lordship.
Okay. But Mr.
Yeah.
A. Ahmed, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional PP, appearing for the state respondents. The present interlocutory application has been instituted seeking pre-arrest bail in connection with Nilam Bazar PS case number 96/2023, registered under section 366 bracketed A of the Indian Penal Code. Also, Mr. Sharma has produced the case diary. So I perused the statement of the victim girl, wherein she has stated that she had eloped with the petitioner hearing on her sweet will. So she has further submitted that what is the exact statement?
Lordship, first statement is 164. In the 164, she has denied entirely. She did not take his name, Lordship. I think to protect him, she said that she was staying in the friend's house. Thereafter, Lordship, when this petitioner was granted interim protection, he was directed to appear in the police station along with the victim girl. Thereafter, they appeared, and now she has stated, Lordship, that we have already married.
She is given a statement.
Only the note of the IO is there, Lordship, that the victim girl has stated so and so, so and so.
Key liaison. No. She has seen the statement of the victim girl, wherein she has not implicated the petitioner hearing. So there is also a note of the investigating officer wherein it has been recorded that the petitioner, the victim girl has submitted that she has married. Have you married her?
Yes, we have in fact stated in our petition also.
Married the petitioner hearing. So in view
She also denied medical, Lordship.
and further, she also denied to subject herself to medical examination. So in view of the above position, the interim pre-arrest bail as granted to the petitioner hearing wide order dated 26/7/2024 by this court, wide order dated 26/7/2024 is made absolute. With the absolute, no further condition is required. Mia Bibi Raji. Huh? The petitioner shall cooperate, subject to the condition that the petitioner shall cooperate, continue to cooperate with the investigation of the matter. Bail application stands disposed of.
Oblige.
Now leave happily.
Oblige.
39, Lordship, just one submission, Lordship, the petitioner is already on interim. We need to update the case diary with the medical.
Mr. B. Sharma, learned additional PP submits that he be granted a week's time to place on record the updated case diary. Prayer accepted. The present case diary be retained, will be returned, and on the next date of listing, an updated case diary be so produced. Registered to list these matters when?
Lordship, let it be on 20, Lordship, he's already.
29/2024. Interim order passed earlier to continue till the next date.
Lordship, we have already appeared before the IO. Oblige.
Let Mr. Sharma has his satisfaction.
Item 40 along with item 11.
Yes.
Yeah, Lordship, what has actually happened? There was one warrant issue. Because Lordship may, in item 11, the Lordship may kindly take my representation, which I have given.
No, this Rafiqul Islam is the same one.
No.
Same one, Lordship.
Ishaq.
No, Lordship, no, not at all. That is why I'm saying if your Lordship kindly take up page 38 for a moment of time.
Which one?
In item number 11. May I just read it out, Lordship? Annexure 4, page 38. It is a representation given by me to the.
By the mother.
By Rafiqul himself, Lordship will kindly appreciate. It is by Rafiqul Islam. It is a case of mistaken identity, Lordship.
Yes, what do you say, Mr. Sharma?
Lordship.
Affidavit.
Let him finish his argument.
Okay.
Lordship, may I just read out? It is a very small representation. I'll just read it out, Lordship. I'm coming to the pertinent part, Lordship. From paragraph number 3, Lordship. that in the year 2022, District and Session Judge Morigao issued a summon to one accused named Rafiqul Islam, son of late Isha Haq of village Hatasim Mulgori, PS, Dhikiajuli district, Sonitpur. So, Lordship, kindly see it is district Sonitpur. My district is Udalguri, different district altogether. In connection with NDPS case number 84 of 2022, did an IC of Borsola served summon upon one Rafiqul Islam, son of Ichak Ali, village so-and-so, district Udalguri. That is myself, Lordship. Through VDP secretary, and after receiving the summon from VDP secretary, the aforesaid Rafiqul Islam, son of Ichak Ali, village so-and-so, 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 appeared before the IC of Borsola outpost. That is, Lordship, I appeared, along with VDP secretary, and clarified that he is not the person upon whom the summon was served by the learned court. And in fact, in the village Fatasimul under Ural police station, there is another person, namely Rafiqul Islam, son of late Isha Haq Ali. Lordship, kindly see the name. My father's name is Ichak Ali. And here the person who is a warranty, his father's name is Isha Haq Ali of village Fatasim Mulguri, PS Urang, district Udalguri. And after clarification from Rafiqul Islam, son of late Ichak Ali of village so-and-so, so-and-so, there was no such type of summon was ever served upon Rafiqul Islam of village so-and-so. That in the meantime, 2-3 months ago, one warrant of arrest was issued in the name of Rafiqul Islam, son of Lord Ichak Ali, so-and-so, in connection with NDPS case number 84 of 2020. In stand of that warrant, the arrest of the earlier Borsula outpost tried to arrest Rafiqul Islam, so-and-so, Lordship will kindly see, willfully appeared before the IC Borsula outpost of Dhekajuli police station. So I appeared, Lordship. Now what the Dhekajuli IC has to say? And the IC Borsula outpost after...
Okay, forget it. That is your representation.
Yes.
So you say that this Rafiqul Islam is not the Rafiqul Islam involved in the NDPS case. That's all.
Absolutely.
Yes, what do you have to say?
Lordship, Lordship will take up item 11, paragraph number 5, there.
5 of the petitions.
5 of the petition.
Yes, Lordship, 5 of the petition.
Hmm.
There, Lordship, Lordship will kindly see 4th line, Lordship, the petition number 1 told the informant that her son, Rafiqul Islam, is not the accused against whom NBWA has been issued in NDPS case number 84/24. And the petitioner number 1 also informed the police that the case number is wrong and it has to be NDPS case number 84/22. So, Lordship, that is their statement. It should, the summon issued to the person by the name of Rafiqul Islam, the correct case number should be 84/22. Now, next thing, Lordship, they have stated that when the police came to the village to arrest this Rafiqul Islam, Lordship, that they could not arrest him. That is stated in the FIR. But what has happened from the allegation, Lordship, when they approached the village, Lordship, the VDP secretaries showed them the house of the Rafiqul Islam. Thereafter, Lordship, he was arrested. After that, Lordship, the family members assaulted the police officer after he was arrested, and they managed to rescue him and managed to let him escape.
I got everything. I
Yes.
got everything. Whether he is the one who was rescued,
Yes,
he was the one.
he is the one, Lordship. Why I'm stating, Lordship, once again, 84/22.
No, that because the earlier notices were coming. Earlier notices was coming, so that may not be very vital.
Let me
That is vital, Lordship. That is vital, Lordship, because they are stating that the case registered against the Rafiqul Islam is 84/22. That is their statement, Lordship. I have received the copy of the summons that was sought to be implemented on that day. It is 84/22.
22.
So that's it, Lordship.
Now let me
What
say,
more is
Lordship,
there?
we have verified from the court, Lordship.
So in the case diary, there is no doubt with regard to the identity.
Absolutely no doubt, Lordship. The statement
No,
of the
now-
VDP secretary is there. He has shown them the house. What more is required,
Mr.
Lordship?
Now let
Acharya,
me-
sorry.
Now let me clarify, Lordship. If your Lordship can.
This is too a long story to have
No,
accept.
Lordship, let me kindly clarify, Lordship.
Hmm.
We have verified from the court concern, Lordship. 84/24, there is no number of NDPS called 84/24.
No, he says that the summon is
No,
84/22.
Summon, Lordship. Copy of the summon
It
is here,
is
Lordship.
wrongly written, Lordship. Lordship may kindly call for a report from the court concern.
Forget it.
And
Not needed, Lordship.
let me submit, let me make my submission, please.
Mr. Vachaji,
Okay.
your case is of mistaken identity.
Yes, Lordship.
That is not acceptable.
That. Lordship may kindly call for a report from the.
I'll not call for any report.
Lordship may kindly call for a.
Ishaq
report.
Ali Rafiqul also Ishaq Ali
No, Lordship.
and
I have given the. notice,
serve
Lordship.
someone upon one so and so. And the
Lordship,
VDP secretary making, you go
secretary,
and establish,
VDP secretary.
you go and establish before the
VDP
court.
secretary is the cousin brother of the main person. He is misleading the police.
Where is that material?
Secretary.
Where is that material?
Because in my petition, it is not there. It is in their petition. I am not representing.
Okay, Rafiqul, yes, Rafiqul.
Please come.
My plea is almost same, my lord.
Huh.
That we have approached before the police, we filed before the representation before the DGP.
Hmm.
And my lord, this is clearly a mistake in identity, my lord.
But the police has got no such doubts.
My lord.
Police has got no such doubts.
My lord, in fact, my lord, that's on that night, my lord, there was a misunderstanding arised between the police and the local.
Why would the VDP secretary go and show your house?
Because Lordship.
My lord, in earlier time, my lord, police came. Then BTP secretary, I approached before the BTP secretary. Because BTP secretary also says that it is not the Rafiqul Islam who am I. On that time.
Where is those materials? You are making a submission. Where are those materials?
My lord, then my lord, I will be allowed to sometime I will file an additional.
Absolutely not. Lordship, I have the copy of the summon, Lordship.
Let him have his full satisfaction.
That copy of the summon may kindly be verified from the court concern.
Well, I'll not even do anything. I'll not have not even heard him. I want you to establish this.
Lordship, then let us.
Then I will file a.
Let us
On the
bring-
prayer of the learned counsel for the petitioners.
Lordship, let us bring a report. Let us file another affidavit, bringing a report from the court concern.
You do whatever you
Yes,
want.
Lordship. And another.
Raised it to
question
list this matter again
that is-
on
another question that is-
23/9/2024.
Lordship, another question that is pounding in the mind, Lordship. You will kindly see that here, the person concerned who is executing the warrant, Lordship, is a SIP. Sub Inspector of Police probationary. Until and unless a SIP is appointed by the government as an in charge of a outpost, Lordship.
I'm sorry, I'm not here all those.
Lordship, we may be allowed to send back the.
The case diary receipt shall be returned and produced on an updated case diary be produced on the next date of listing. You also get a report with regard to this.
I've already informed, Lordship.
Should I make a note?
Not necessary, Lordship. I already-
23. You, Mr. Vachari, if you want to make submissions, please bring those materials on record. Okay.
Lordship, charge sheet has been submitted.
Charge sheet has been submitted. Appear.
I have already appeared before the concerned IU, Lordship.
No, you appear before the, now go for regular bail. Charge sheet has been submitted. Number?
110/24 dated 30/5/24.
110/24 dated 30/2024 before.
Lordship. Before Lordship, Honorable Court of CJM, Amingaon.
Kamrup Rural.
Lordship,
They don't write Kamrup Rural, na? Kamrup Amingaon.
Amingaon.
You're on you're on interim.
Yes.
Heard Ms. T. Learned Counsel for the petitioner. Also heard Mr. B. Sharma, Learned Additional PP. The present bail application has been application has been filed for praying for pre-arrest bail in connection with Polasbury PS case number 174/2024 under section 447/294/325/326/427/506/34 IPC. So, this court had wide order dated 5/6/2024 on consideration of the issue arising in the present proceeding, enlarged the petitioner on interim pre-arrest bail. So, it is submitted by the petitioner that in terms of the directions passed by this court wide order dated 5/6/2024, the petitioner had appeared before the police and recorded his statement. So, Today, when the matter is taken up, Mr. B. Sharma, learned additional PP, has submitted that the charge sheet in the above noted case has been submitted, while charge sheet number 110/2024 dated 30/5/2024 before the court of the learned CJM, Kamrup, Amingaon. So, in view of the above position, the petitioner herein is directed to approach the trial court for regular bail. Also, within a period of 15 days from today. Also, for the period of next 15 days from today, the interim protection as extended passed by this court wide order dated 5/6/2024 shall continue to remain in force. With the above observations and direction, the bail application stands disposed of.
Ditya.
80 lordship after some time lordship.
After some time.
After some. I guess.
Why should we keep Mr. Rashid waiting? We'll have it on at 2 p.m.
Yes. 2 p.m.
You go have your tea and come back.
It was.
May I please, your lordship, in this matter, we have taken steps, first step
When?
on the respondent number 2, my lord.
When?
Today.
The learned counsel for the petitioner submits that in terms of the Laujima court's order dated 2/9/2024, fresh steps have been taken upon the respondent number 2 today. So, registry to issue notices to the respondent number 2 and thereafter list this matter again after 4 weeks along with the status report with regard pertaining to service of notice upon the respondent number 2 here.
Obligement.
Finally, this matter may take any other day, lordship.
On the prayer made on behalf of the learned counsel for the petition, registry to list this matter after
On 11th, lordship.
2 weeks, after 2 weeks, on a date to be fixed by it.
Obligement.
Eight illegal lodge. So as per the laws, you report service upon the respondent number 4 is completed.
Nobody has appeared.
Nobody has appeared. But the AD card has been marked in there.
Seen the note dated 38/2024 of the Lazimal Court. The service of respondent number 4 is complete. Also, the service report of service upon respondent number 3 is awaited. Also, it is contended at the bar that the respondent number 4 is the partner of a partnership of the respondent number 3 partnership firm, and accordingly, also. But it has its own individual identity, Mr. Counsel. It's a firm. It has it's a legal. You take fresh steps once more. In view of the above, the petitioner to take fresh steps for issuance of notice upon the respondent number 3 steps within 3 working days. On receipt of the steps, the registry shall issue notice by way of registered post with AD to the respondent number 3 Registry to list this matter again after 4 weeks, along with us,
Interim order was.
along with a report on the status of service of notice upon the respondent number 3. Interim order passed earlier to continue till the next date of listing. Registry to list this matter again after 4 weeks on a date to be fixed by court.
This is a review petition. Your lordship may kindly take it up after some time.
What is your, okay, Mr. Bhattakur,
Obliged.
after some time. 2 o'clock, second half, now it's not, second half.
Meet please, Your Lordship. Chief, as per the last order, steps were taken on respondent number two to the public prosecutor, but no report has come.
Yes, Mr. Professor.
My lord. We have one inspection, my lord, we have to take, my lord.
Mr. K.K. Professor Learner additional PP submits that he has not received the instructions with regard to the service of effecting of service of notice upon the respondent number 2. Respondent number 2. And accordingly prays that he be given 2 weeks' time to receive the said instruction. Prayer accepted. Registry to list this matter again after 2 weeks. So, Mr. Parasar on the next day of listing shall place before this court instructions received from OC Morigaon Police Station pertaining to service of notice upon the respondent number 2.
Obliged.
I have for condemnation of delay, my lord.
I'm opposing, I'm on behalf of the opposite party complaining. Actually, the facts in a nutshell is that the learned court below had using discretion under section 143A of the NI Act had issued the direction to the accused person to pay 20% of the check value. And as against that order, they preferred this revision with the application under section 5 with a delay of 45 days. Perusal of the application under section 5 clearly shows they have not made out any sufficient grounds for condemnation of the delay. In fact, the order that was passed on 26th of September itself. Delay condemnation is not merely for the asking. And that too when the learned court below has exercised the jurisdiction best.
But that, your lordship, they can take their objection in the main criminal revision also one.
No, we are on the whether they have made out sufficient grounds for condoning the delay.
Case is complex case has been filed in Nolbari, my lord. And the petitioner is a resident of Guwahati.
If your lordship takes up
So
our
there was some
objection,
delay, my lord, in getting the certified copy of the order, my lord.
Okay.
As such, this delay was caused.
there is
Okay. Now come to para 3.
My lord.
Para 3 of your petition.
Well.
Your case is that there was delay in getting the certified copy.
My lord.
See when you have applied for the certified copy.
My lord, what happened, my lord, order was passed on 26/9/2023, my lord.
Hmm.
And there was an assurance by the legal counsel that they will file a review for this order, my lord. And as
For
such,
that
the
also
next
you
date-
require
next
a-
date fixed was, my lord, 1/12/2023, my lord.
Hmm.
On that day, when they did not file any review as against the 20% compensation, my lord, then, my lord, order certified copy was applied.
But you have not mentioned that
nothing.
to that extent.
My lord, I have that.
But when nothing was done, the petitioner applied for a copy of the order dated on 1/12/2023.
And how can a criminal court have a review power?
My lord,
A review power is not with the criminal court.
my lord, because my lord, if your lordship will come to the main revision petition, my lord.
I'll not go into the revision. I'm
Yes,
with this.
madam.
Okay,
Yeah.
now you come down, para 3.
My lord, there are three, my lord. What happened, my lord? 20% compensation was directed.
I got
to
it.
Paid on 26/9.
I got
my
it.
lord.
I'm
And the
not
next day it was fixed on, my lord.
I'm not on that. Para 3, I am with you. Para 3, there are two para 3s.
My lord.
The second para 3. It should be para 4 actually. I'm with you in para 3. I give you the benefit.
My lord, there are
I'm not that technical. Now come to para 3. Thereafter approach the council to discuss the matter in the month of January 24. No date. Wake.
after receiving the copy, my
So,
lord. During
1/12 you got the certified copy.
No, my lord. I
Where is
applied
that
for the
date?
copy on 1/12, my lord.
Where is that date?
My copy was received, my lord. Copy was received in the last part.
4/12. No, you received it on 4/12.
My lord, because that was in Nalbari night.
Where is that? Thereafter that, then nothing. In the last part of December from the council at Nalbari and the courts were closed. Due to last part of December, the court is closed.
My lord, High Court was closed, my lord. It should have been filed on, my lord. from
Not very,
26th of,
your this grounds are. Now you come to January 24th.
My lord.
Could not provide all the documents necessary to so and so, the petitioner provided in the first week of February.
My lord.
And accordingly, a draft was made and it was finalized on 5/2. And along with the condemnation petition is being filed before this court on 8/2.
My lord.
Now, if you can come to your petition, this was not filed on 8/2. This was filed on 19/2.
No, my lord.
Come.
It was filed on 8/2, but it was registered on 9/2.
No, this is filing.
9/2. my lord.
No, 9/2 is your thing. But
Registration day, my lord.
no,
It was registered on 9/2. my lord.
it's filing. Seal is of filing. That is when it is received.
Yes.
It was submitted on.
But
8,
I
my
find
lord.
that you have
It was-
submitted the
It
copies
was
on
registered on 9, my lord. On 9 February, it was registered.
9/2. Okay. Okay.
Lordship, all contradictory facts. And he says that on 26, the order dated 26/9 certified copy he applied on 1/12.
Okay, fine.
Thereafter court
That is English language being used. But
Again, after
motamoti,
that, only,
motamoti, it's there.
only after the view vacations, Lordship, sufficient ground should have been made out for the condemnation of the delay.
Okay, fine.
Not in this manner.
You contest on merits. Contest on merits.
Of course, Lordship merits,
You have a very good case on merits. Well, dismiss it on merits.
definitely, but when the sufficient grounds has not been made out, that is what we
Sufficient, okay, fine. That we give a benefit to the advocates. Because see, what he has said, that he and his advocate can only know. Naturally, they might have given him an assurance that we will do something. So the petitioner, why should he suffer? We are only giving him an opportunity to have that order tested, and 45 days.
45 days, yes. But nothing also enclosed, when was the certified copy applied, when he, nothing on record. At least that should
Well,
have,
dear Borga, I have found that 1,000 days also you have got it delay condoned when you are decide. But good grounds, better grounds.
Lordship, there may be occasions, Lordship, when we have made out sufficient.
Delay is not, the number of days is not worried.
Yes,
What
yes.
the
Only
explanation.
that sufficient cause.
On what happened on 26/9/2023 in the court below?
26/9, the order was passed directing him to pay 20%.
Mm.
After that, the next date was fixed on 1st of December 2023.
Mm.
On the next date fees, he did not even care to appear before the learned court below, the accused person.
When is the next date now?
Now the next date I'm told is on 3rd of October, it
Third of
seems.
October. ma'am.
3rd of October.
Okay, before that, we will finish up revision petition. But Mr.
As per us, sir.
As for us, learned counsel for the petitioner. Also heard Ms. Deborah Guy, learned counsel appearing for the sole respondent.
Sole respondent.
Sole respondent. The present interlocutory application has been so instituted, praying for condonation of 41 days delay in filing the revision petition. So the learned counsel for the petitioner, by relying on the contentions made in the petition, in the interlocutory application, has submitted that the petitioner is at no fault for the delay so occasion in instituting the connected criminal revision petition. So accordingly, he submits that the delay so occasioning be condoned and the matter and the connected criminal revision petition be taken up on merits. So the said prayer is vehemently objected to by Ms. Deborah Guy, who submits that the causes shown by the petitioner are all vague. Causes shown by the petitioner for condonation of the delay are all vague and does not inspire confidence. Accordingly, this court would be required to dismiss the interlocutory application, refusing the petitioner the benefit of condonation of delay in instituting the connected criminal revision petition. I have perused the materials brought on record. I have heard the learned counsel for the parties and also perused the materials brought on record. Also, while concurring with Ms. D. Buragahai that the statements made in the interlocutory application by the petitioner could have been better framed or would have been better projected, it is seen that the petitioner had brought on record the reasons as to the delay occasioning in the matter. At the instance, firstly, it is the contention of the petitioner that the matter, he is a resident of Guwahati and the matter was pending in before the court at Nalbari. And accordingly, on the basis of the assurance given by the petitioner counsel therein, that necessary steps would be taken in connection with the directions passed by the wide order dated 26/9/2023. The petitioner had not taken any steps. However, on the next date of listing of the matter on 1/12/2023, finding that there was no step taken in the matter by his counsel, the petitioner had applied for the certified copy, which is contended to have been received by him in the last part of December. Thereafter, the petitioner had contacted a counsel at Guwahati and the matter on being drafted and finalized on 5/2/2024 was filed on 9/2/2024. Also, considering the said position, this court is of the considered view that the delay in the matter requires to be condoned, and accordingly, the delay of 41 days in preferring the connected revision petition stands condoned. Also, interlocutory application stands allowed. A criminal revision petition in view of the order passed today in I Criminal 177/2024 raised the present criminal revision petition and list the same for motion. It comes for admission. For admissions.
47 also same order.
Better projections next time. This type of projections we will next time throw it out.
They serve a copy of the revision
Serve
petition,
a copy of the criminal revision petition. Be very careful when you make those statements. It is right to the next. But considering that advocates had done something, we have condoned it.
No.
Much of
Two cases, same.
47 also, my lord,
same, my lord. Order
Same.
passed by the trial court is also same, my lord, same date, my lord. Delay is also, my lord, same, my lord.
Same order, দুটা আয়ে হব, আয়ে দুটা কৰি দিবা। Okay,
Not only.
বেলেগ বেলেগ কে মাৰি দিবা। You will get these orders by Monday only. Because I have a shortage today, Monday.
Thank you, Your Lordship.
Hmm.
Lordship, this I has been filed praying for implement of the informal lordship. Like granted email petition.
Okay. The present interlocutory application has been instituted by the petitioner, praying for impleading the informant as respondent number 2 in criminal petition number 952/2024. I peruse the contentions made and I've also heard Mr. P.S. Learned Counsel, Learned Additional PP appearing for the respondent number 1. So, I've considered the learned submissions made by the Learned Counsel and also perused the material, the contentions made in the interlocutory application. So, this court is satisfied that this court is of the view that the respondent number 2 is a necessary and proper party to the proceedings, and accordingly, it is directed that Muhammad Hussain Ali, son of late Abdul Kadir, a resident of village Dogao, P.S. Juria, district Nogao, Assam, PIN 782124 be impleaded as a respondent number 2 in criminal petition number 952/2024. So, Yarahiba. In view of the order passed today in criminal. So IAC saying IAC, now it becomes IAC only. IA criminal 782/2024. And so and so is impleaded as a respondent number 2. Petitioner to file an amended cost title in the matter. Also, within 3 working days from today. On filing of the amended cost title, petitioner to take steps for issuance of notice upon the respondent number 2 by registered post with AD. Steps 3 within 7 days from today.
Foxo is there, Lordship, so they will take steps through the PP, office of the PP.
Registered post with AD no like through the office of the learned public prosecutor, Guwahati High Court, Assam.
DP obliged.
Yes, Mr. Bhattav.
Item number, Your Lordship, 44, Your Lordship. Your Lordship fixed it to Your Lordship. I have some difficulty, Your Lordship. On
When?
Wednesday, Your Lordship.
Wednesday or Thursday? Wednesday.
Wednesday.
Item number? Because if what you have said in your review petition is correct, then how can I rely on the instructions?
I have, my review is based on the RTI reply, Your Lordship.
But I have again checked up. Categorical statement, all posts filled up. Let's see, Thursday. Thursday. Item number? 44, Thursday. On the prayer of the Learned Counsel for the parties, list this matter again on 12.
Lordship.
12.
Obliged.
Yes, Mr. Bora. Yes, Mr. Chaudhary. What happened? Friday.
I will seek permission to meet your lordship in chambers, madam.
Huh? Yeah. Yes.
My item is, my lord, 52, my lord.
What do you want to do it or
52, my lord.
you are there?
No, Your Lordship, I am in 55, Your Lordship. I am also.
Okay. Hearing matters, we'll have it next week then.
Close.
Because I don't know whether I'll be in this bench or not. So 52 when, Mr. Bora?
Next week, my lord.
Next week. Next week, we do. At the Learned Counsel for the parties, as prayed for, list this matter again. Date it, Adibo? 53? When?
Next week.
Next week. 54 also, ekkalage, 53, 54 ekkalage, 55,
55, your lordship, on 24.
24. 24 9.
Alright.
It doesn't. Thank you. Order development doesn't. It was second upon ticket. Hey, it's all to put it in second. Monamika, Matadi, but I do tell that I would. What do you go? No, ये तो number to भूले चले. Yes. But I am taking up above 7 years. Huh?
But the court we mentioned, it was informed to us that my Honorable Mr. Justice, Mr. Justice Khan would not be sitting after 12 o'clock. So that's why we're constrained to move this application before this Honorable Court, which was however allowed.
But no, when the matter is not assigned to me, without the registry assigning it to me, I cannot. So what we do is that we'll ask it to be listed on Monday.
Monday, some difficulty, my lord, out of station.
Tuesday. The present matter, the full of the Anani. Titella Koidia, it Tuesday listing already. Well, appropriate court, Tata listing already. He'll have it.
If I may take that much of liberty, if
I cannot, because when it is not assigned to me by the Chief Justice, how can I come in? If it is within my
yes, I understand.
purview, I'll do whatever I can, but within is not, I should not be. Why? Rake up unnecessary. But I did not know, because that normally sitting in a civil bench,
yes,
these issues are new to me. So from today onwards, I'll also be asking whether it is 7 low or up. Thank you for that. Yeah, Mata. Ha, ha. None appears for the petition on call. Registered to list this matter again after a week on a date to fix by.
50.
That's why I'm mapping for 1 to 4.
Yes,
He is appearing lordship on the respondents.
all the respondents.
No, 1 to 4, madam.
1 to
5 is the government.
5 is the statement. Yes, what do you have to say to it? Shall we consider it today, or you want to file? You want to file? Heard Mr. D. Monto, learned counsel for the petitioner. Also heard Mr. R. Barua, learned counsel appearing for the respondent number 1 to 4. Mr. K. Parasa, learned additional PP appears for respondent number 5. Service in the matter is complete. So Mr. Barua submits that he be given a week's time to bring on record the stand of this respondents represented by him in the matter. Prayer allowed. Registry to list this matter again after a week on a date to be fixed by it.
Black.
My pleasure, Lordship. Lordship, about respondent number 2, notice is yet to be served. But my apprehension is that, my lord, matter will become infructuous whenever the notice will serve, because the matter has been fixed for argument on 18th of September. So if it's over.
Mr. K. Parasa shall receive instructions and place the same on the next date, place the same before the court on the next date of listing as with regard to the status of service of the notice upon the respondent number 2. Registry to list this matter again on 11/9/23.
Much obliged.
Mala scan copy also call for, but it is may not be received, mala, as per cause list not received, mala. So reminder maybe, mala. On 2/8/24, mala. Call quotation.
No, scan copy has not been released.
Mala, okay. Okay, mala.
No,
My
for the
mistake.
time being, let it not be there.
Mala.
Much obliged.
Hmm. Alekha. Yes, Mr. Parasar, what was there in the case diary? Nothing.
No, 19
No,
is AB, mala, motion में था, mala.
I think we have disposed it.
Time being was there, yes.
It order can't touch me.
Well, only item 92, your lordship has asked me to take instruction regarding.
Oh, no, this matter, I think we should allow it. What is there? Just see.
19.
Who is there? Mr. Soma, Mr. Parasar, Mr. Bhattakur, who is there?
Yes, my lord, item number 19, my lord, I was there at that point of time.
Oh,
AB 2349/24, my
I
lord.
think we should allow this.
Regarding item number 22, I have received the instruction.
No, that will come.
Yes,
What do you say about this?
19, my lord.
M. Khan. Any objection? 19.
No,
We'll pass orders.
yes,
Nothing is there. What do you say?
yes,
Heard Mr. M. Khan, learned counsel for the petitioner. Also heard Mr. P. Bhattakur, learned additional PP representing the state respondents. The present application is instituted praying for pre-arrest bail in connection with Gitanagar PS case number 164/2024 under section 420/406/376 IPC. Also, I have perused the FIR dated 13/8/2024, which had led to institution of the above noted case against the petitioner hearing. On perusal of the same, along with the FIR filed by the petitioner hearing against the informant in Gitanagar PS case number 164/2024, which was registered as Dispur PS case number 382/2024 under section 356/379/384/387/34 IPC. I'm of the considered view that given the nature of allegation so leveled both by the petitioner and against the petitioner, the same would not require a custodial interrogation of the petitioner hearing. Also, the materials now sought to be recovery of the money from the petitioner. The prayer of the informant for recovery of the money, so stated to have been taken from her by the petitioner, is also a subject matter which is involved in the FIR lodged by the petitioner hearing, leading to registration of Dispur PS case number 382/2024. Also, in view of the above position, this court is of the considered view that further custodial interrogation of the petitioner may not be called for in the matter, and accordingly, in the event of arrest of the petitioner hearing in connection with Gitanagar PS case number 164/2024 date under section so and so 420/406/376 IPC, the petitioner be released on bail bond of rupees 30,000 with like surety to the satisfaction of the arresting authority, subject to the following condition. One, the petitioner shall appear before the investigating officer within 7 days from today and have his statement recorded, comma, and thereafter the petitioner shall continue to appear before the IO as and when called for the purpose of the investigation. Two, he in fact inducement he will disposed of.
22, my lord, as per my instructions, charge sheet submitted.
Charge sheet
On 36/24, charge sheet submitted.
36, yes, 22 years, Mr. Roy Chaudhary. Charge sheet submitted.
No, my lord, sorry, my lord.
Criminal petition, man.
This is a criminal petition.
Sorry, my lord. 20, my lord, this is 20.
It's okay. Yes, Mr.
May.
Yes, Mr. Raj.
My lord, the issue before your lordship is, 125 quasi civil proceeding, whether the court overlooking the evidence given in that proceeding, take a judicial notice of a criminal case judgment where the fact was not proved. Only on the basis of a judicial notice of a criminal case where they have said there is no cheating. So that was taken into judicial notice and overlooking the evidences where they have said that there was no marriage. It was their evidence in the 125 proceeding. And that was the finding given by the trial court, and 125 proceeding and maintenance was directed to be given. That was the only finding.
Yes, Mr. Vishwas.
My lord, it is a fact that two courts, first CJM court and the session court, has upheld the decision. And in that second revision, scope is very, very limited. And
No, I'm not on that. Mr. Roy Chaudhary is on a different plan.
Yes.
He says that in the evidences that were produced, that were adduced in the 125 proceedings, therein the issue whether you are a wife or not,
Yes.
that was not established.
yes,
So the court relied on the decision of the Sessions Court in the rape case that was instituted by you against him.
yes,
And he was acquitted from that on
Yes.
the ground that you are his wife.
yes.
So he says that could not have been reckoned because that was not an evidence before the court. Judicial notice, what do you say on that?
My lord, that they could have come to the court challenging that. They have never come. Now, second revision, they have taken this plea. That plea was also not taken. Today, my
First-
learned friend has been engaged. First time he has produced this project.
What?
Mr. Roy
There is no bar. There is no bar.
Not first time. There I was acquitted, my lord. 125.
No, you have acquitted
No,
in a rough charge.
acquitted on the ground that you are a wife.
Right.
You have
Acquitted on a statement given, not on a fact proved. My lord, I take your lordship to that judgment.
I think we'll have to consider this.
But your lordship will kindly peruse the entire evidence.
Because the whole point of
And
determination
then,
is,
then
can,
And one thing, you are having a female child now, girl child.
yes.
You say it is his.
Yes.
Why was, I just for my knowledge, why was a paternity test not carried out in the matter?
that,
My lord, it is up to they could have challenged that paternity test.
No,
They
it
have
was
never
not,
come.
no, it is not carried out. Why have you not established that? Why have you not prayed for a paternity test?
But when court has
The court has
that
given it is, okay.
it is his duty to challenge that, yes, the child is not belongs to me.
No, that nobody has said the child belongs to him. He has also not accepted. You say that the child is his.
Yes.
If that be so, why did you not proceed or make an application for that paternity?
My position in you see in the society, I have been ousted and my situation is completely different. Last 10 years, I'm not getting 1 rupee even maintenance also.
Your
In
statements,
spite
your
of the
father's
upheld
statement.
by two court.
No, your father's statement, your statement, factum of being a wife,
Yes.
there may be an illicit relationship.
Yes.
Whether that will be enough for 125. The
But
daughter may be liable, eligible.
Even
But whether you will be
without
able-
wife also, but if they live together, not
That is not proved. Your your father's statement is that he took you to his house,
yes.
but he was not kept. She was pregnant 7 months. Thereafter, you took her, he did not accept, came back. So that living together is not there. Act is there. Allegation with regard to a rape, that was there. That was, then you also consented that being a wife,
Yes,
but there is no material that you had married. You had said that there is some social ceremony. He says, when it's a Muslim marriage, there has to
that
be
is not there.
certain.
I have seen, that is not there.
So,
That is not there.
Mr. Biswas,
But
kindly,
what is the fate of my child? They have not
that issue has not come up. That issue has not come up. I'm not touching it today. I think you got to address this issue.
Regarding my second division also, I have got submission on that one.
There
are judgment of High Court also.
But unfortunately, I'll go to the root of the matter.
And sure,
Then come back to the
Sure,
technical.
madam. We will be happy, madam.
I'll
We
go to
want
the root.
it.
I'll go to the root of the matter. Because the statements are contradictory. We'll have it when?
12.
12th. By the time Mr. Roy Chaudhary will also have some time
Yes,
to
yes.
further smoothen his.
I'm sorry, Milord, I was not
No,
present.
Mr. Chaudhary, please don't make such submissions. We understand. We understand. There is no problem for her.
Okay.
Anytime, if you're having any inconvenience, make a mention, we'll accommodate.
Okay.
28,
Now you can say, charge sheet submitted. Mr. Bhattakur, now you can say charge sheet submitted. Charge sheet submitted.
Yes.
When?
On 36/24.
Bah, so far.
CS
Can
number,
scan copy of the charge sheet be called from?
No, 3624.
CS number 91/24. Section, my lord, not.
Heard Mr.
Yes, that's fine.
Yes,
Can the scan copy be called from?
yes, thus, as thus,
Yes, yes.
no, learned counsel for the petitioner.
My lord,
Also heard,
At this, section 302/34. Let him appear before the trial court, or otherwise, my lord, if
this
He's
is before
already in
me.
custody, man.
He's already in custody, BA.
He is already in custody.
yes,
So I'll consider.
yes.
We'll call for the scan copy of the case diary. Okay? Huh? Is it proper?
Yes, sir.
Normally, when they file the cases, when charge sheet not filed, then my lord, direction is to approach the court below. And if already succeeded case and now approach the court, then scan copy called. This is the practice. my lord,
Already
going on.
pending. Your lordship may consider my.
No, he filed it only in August. Charge sheet was filed in 36.
But yes, that
So-
was not.
That was not known, so we'll go by that second proposition. Mr. also heard Mr. P. Bhattakur, learned additional PP, appearing for the state pro. Mr. Bhattakur submits that the charge sheet has been filed in the matter. White CS number 91/2024 on dated 36/2024 before the court of the
CGM Kamrup Metro.
CGM Kamrup Metro, raised it to requisition a scanned copy of the charge sheet so filed and tag the same with the records of the case.
Well, LCR along with case diary, man,
LCR along, scan copy of the LCR,
and CD, man.
LCR. CD you produce,
No, my lord, already.
one copy goes, where are the other two copies?
My lord, normally, my lord, he submitted before the court. Now it has to be come from the court, my lord.
Along with a scan copy of the case diary.
Well, there will be a PRC number, man, of that case. Once the charge sheet is put up, there will be PRC.
Let's
My
see.
lord, now difficulty is that, my lord, those numbers, my lord, he has not mentioned in this, my lord, present
Okay,
petition, my lord.
fine.
PRC case.
Fine, that
etc.
case, charge sheet number has been given there.
It
They
will
will-
be
they will find
difficult
out.
to, my lord, charge.
How long does it take for this to happen?
Ma-
1 week, 10 days?
23/9, man.
23, list this matter again on 23/9/2024.
Highly of this.
Well, registry to list the case on receipt of the LCR and CD, man.
It will never come.
It has,
23-9 along with this.
it has to be bring by the registry.
Registry only I said.
No, madam.
Registry will requisition it and then 23-9 will list. আৰু এটা থৈছিলো নহয় লিখিব এইটো Hmm?
31. 31.
30-31 you are appearing for your name
Is it Ahmed?
AZ Ahmed. Morning who appeared?
Morning, Hafiz to the Sarakuri appearance.
Yes, Mr. Bodago.
Yes, my case they received at that point of time, my lord, I pointed out to your lordship, my lord,
Hmm.
that here.
Some problem there, huh? Did that? Hmm. Hmm. Huh. Now it.
So, my lord, here, though, although injury report is not available, but the statement of the injured person is available. As per the statement of the injured person, my lord, he implicated the my lord, petitioners of item number 30. He
Item
implicated all the
number-
petitioners of the item number 30, but he has not implicated the petitioners of the item number 31, my lord.
Okay. Okay. Hmm. Okay. Item number 31 to law. Heard Mr. H.R. Chaudhary, Learned Senior Counsel, assisted by Mr.
Khalek.
A. Khalek, Learned Counsel, appearing for the petitioner. Also heard Mr. P. Bodhaku, Learned Counsel, appearing for the Learned Additional PP for the state respondents. Subchar, PS case number 39. Okay. The present application has been instituted seeking pre-arrest bail in connection with Subchar PS case number 39/2024 under section 120B bracketed B oblique 341/326 352/307 379 427 IPC. Also, the above noted case was so registered basing on an FIR lodged by who was the informant there? Muzaffar, by one Muzaffar Sheikh, alleging that the petitioner herein, along with the other accused persons, had assaulted his younger brother, alias younger brother Mukul Haq, and snatched away an amount of rupees 40,000 from him. So it was further alleged that there was a conspiracy to kill the younger brother of the petitioner. However, on account of interference by the local people, such action could not be taken, could not be performed. Such act could not be performed. Also, Mr. P. Bodhaku, Learned Counsel for the petitioner, has produced the case diary. So the case diary contains the statement of the injured of the victim Mukul Haq, and from the statement it is seen that the said victim had not implicated the present petitioners, right?
Yes, sir.
31 present petitioners in the matter. Also, in view of the above position, comma, and also in view of the above position, this court is of the considered view that a case has been made out by the petitioners for being extended with the privilege of pre-arrest bail. Also, accordingly, in the event of arrest of the petitioners herein, in connection with Eke Kotha under section so and so, they shall be released on bail of bail bond of rupees 20,000 each with like surety to the satisfaction of the arresting authority. Full stop. With the following, subject to the following conditions. Again, appear go back
Allowed both the person.
No, the second one I'm writing. Say next one. BA 2241-2024. A date of arrest?
Lordship, 24/6/2020.
2024. So, একেটাই কথা লিখিবা 30 একে হব but কিন্তু regular bill প্রথম paragraph দুটা seeking so and so Mr. P. Bhattacharya, Learned Counsel for the Learned Additional PP has produced the case diary and has submitted that the victim Mukul Haq has implicated the present petitioners and he has contended that it was they who had attacked him on the fateful day. Also, and had also sanctioned snatch. They had snatched his money also.
Regarding snatching of money.
Nothing
that
is there.
Not.
Snatching nalai, huh? Also, Mr. Bhattacharya accordingly submits that the present petitioners would not be entitled
Yes,
to
for the
be
last portion he has mentioned that they also snatched the money also.
money also, and also snatched money from him. Also, Mr. Bhattacharya, basing on the said revelation made from the case diary, submits vehemently opposes the grant of bail to the present regular bail to the present petitioners. Also, I have considered the submissions made by the Learned Counsel for the parties and also perused the case diary. Also, the said materials being available, however, considering the period of detention undergone by the petitioners hearing, considering the fact that the petitioners hearing were arrested on 24/6/2024 and considering the length of detention undergone by them, this court is of the view that the petitioners, no further custodial interrogation of the petitioners would not be called for in the matter, and accordingly, the petitioners herein are entitled to be enlarged on regular bail. So accordingly, it is directed that the petitioners herein be released on bail by furnishing a bail bond of rupees 20,000 each with like surety to the satisfaction of the CGM
South
Salmara
Mankasa.
Mankasa. Full stop. Well, subject to the following condition. Appearance, one, they will cooperate with the investigating officer in investigation of the case. Also, that adduce to the one it's the that to do. Oh, disposed of.
Regarding, I would like to point out one thing already, Your Lordship, regarding that search-sheeted matter, my lord. Your Lordship has already called for the LCR and CD, my lord. Now, my lord, what happen if any BA is pending here, my lord, in all court, my lord, in case of if search sheet file, then, my lord, the matter is disposed of, after disposing of the matter, petitioner is asked to appear before the trial court for obtaining regular bail. And now here in this case, my lord, what cognizance is not yet taken by the trial court. Then PRC number, whether registered or not, my lord.
We only one day, we have not put a PRC number. We only ask for a copy of the
Yes.
charge sheet. If there is something incriminating material, we will not.
Otherwise, my lord, thereafter what happened? It is the duty of the petitioner to finding out their number. He again can approach before this honorable court.
Now, if you tell me these things in installments, he is not even here. He might have gone home now.
Yes, ma'am.
Next day, you tell me this.
Yes, yes.
And be one thing, when I'm sitting, if something is there, come up and tell me.
Yes.
77, I'm sorry, my lord, that not yet received, we have communicated, my lord, maybe taken last item, my lord, I have again. That regarding the health condition of the, and search sheet already, but under what section, these are specifically not yet received, I have twice, my lord, telephonically informed, my lord. As a last item.
Okay. Where did you know that?
80, my lord, that yesterday's matter, one, my lord, allowed. And I have, my lord, thoroughly gone through the case, very, my lord. Yes, that husband, my lord, yesterday, counsel stated that he was not there, he went, but that is not correct. My lord. He was there, Mohiuddin was there. on
Heard
the day.
Mr.
No,
Rashid.
but, my lord, one thing is that
Mm.
all the members, my father and mother, they went around 7 p.m. to the Dharma Sabha. They went. Mohiuddin also went around 8 p.m. but subsequently returned back. But one thing is that the room, when it is open, my lord, only the disease, she was hanging, and 3 years girl of the disease, and
Any statement of that 3 year case?
and one girl of 7 years. Their statement that door was locked from inside. That 7 years girl opened the door. Other malat, no one is there.
And the mother was hanging when the door was
Yes,
opened.
yes. They are crying. One 7 years girl is not her girl. It is a girl of sister-in-law, both daughter. She is also in that room, and she has girl also in the room. They were crying because of that. When Nani asked to open the door, they opened the door. None of
Why before that they did not open?
that is not there. And one statement, the company is the father of the disease.
Father-in-law of the petitioner.
Yes, father-in-law of the petitioner. He stated that yes, few days earlier when the petitioner went to Arunachal for work, both the disease and the petitioner went along with Malak for few days stay, and they came back. And last he stated that more more karo against nine. That is the statement of the.
But is the room was
A room, my lord, one statement, yes. তাই ভয় খাইছিলে দরজা খুলুতে মোর ওয়াইফে মানে স্টেটমেন্ট অফ দ্য ফাদার ইন ল বিলকিসের শিখলো ওলমে দেখা পাই ঘৰৰ সবকে মাৰিছিলে মানে open by the 7 years old girl.
who was there when she opened the door?
Mother-in-law knocked the door.
Mother-in-law had also gone for that drama hoba.
Yes. Door was open in the morning at about 6 a.m. Door open when she didn't wake up, then.
You go through it nicely. You go through it nicely. Something may be there. Because I just want to know where was the petitioner's presence after 8 o'clock?
Petitioner after 8 o'clock,
When he came back, then what happened?
When came back, that is.
That you find out. Maybe somewhere.
From the SR itself, there is no direction that I was involved there, I was there, nothing is there. And my signature.
What do you say?
Perhaps
We'll have it on Tuesday. You check. Mr. I heard Mr. A. Rashid, Learned Counsel for the petitioner, also heard Mr. K.K. Parasar, Learned Edition PP. Mr. K.K. Parasar has submitted that the case diary has been received. However, he prays that he be given 2 days' time to further peruse the case diary in the matter. Full stop. Accordingly, registered to list this matter again on 10/9/2020. Case diary be retained.
No.
Yes, any information? Other case?
No. I was out of the PS Malad. He has not details not given Malad.
We'll have it on Monday.
Malad.
On the prayer, ito item ID di ba de? On the prayer, on the 70? 77. On the prayer of the Learned Council, on the prayer made by Mr. K.K. Parasar, Learned Additional Public Prosecutor, PP, registered to list this matter again on Monday, 9/9/2024. Ito আজি ইতিয়া পঠাই দিয়ে পঠাও নহলে আকৌ আৰু এদিন দেৰি হৈ যাব
Malad.
হৈ গ'ল